I'm going for YouTube live and this one recording and all this.
Okay.
Just Pita ma'am, you can admit.
Okay. Prasenjit, Mohan Rao sir is there, I think. Make him a co-host, no?
Sir, good morning and namaskar.
Ramakrishna sir, namaste. And
Namaste, namaste. How are you?
very good, sir. Very good. Your blessings.
Yeah.
Very great to see you in this platform.
Thank you so much, sir. I keep hearing about your activities.
Sir.
Right?
Very kind of you. And we have a long-awaited program with you.
Yes, sir. Yes, sir.
And,
That could not happen on that day. It got postponed and then it did not happen.
Yeah.
Sure, sir. I'll make it someday.
Yeah, good. And we have a fabulous feast ahead now, and we are eagerly waiting for that.
Thank you so much. Let me try.
Yeah.
Prasenjit, start.
Okay. A very good morning to everyone. Respected, esteemed resource persons, chairperson, deputy chairperson, and the coordinators of this workshop, including the esteemed participants. I, Mr. Prasenjit Brokakoti, Joint Organizing Secretary of this National Workshop, welcome you all to this last day session. I am very delighted to introduce Professor Dr. T. Ramakrishnan sir as the invited resource person for today's technical session on overview on trademark law. Professor Dr. T. Ramakrishnan is a professor of law and chair professor of intellectual property rights at the prestigious National Law School of India University, Bangalore, which is ranked to be the topmost law college by the Indian National Institution Ranking Framework in 2020. Professor Ramakrishnan did his graduation and post-graduation in law with specialization in international law and jurisprudence, and thereafter an master degree in political science and public administration. He had been awarded doctorate for his research, legal protection of well-known trademarks. In addition to this, he also have a postgraduate diploma in criminology and administration of criminal justice to his credit. Professor Ramakrishnan acted as chairperson, resource person, and invited speakers in various conferences, seminars, and workshops, among which a few of them are International Convention on Intellectual Property Rights, National Conference on TRIPS and its Implications, National Seminar on Contemporary Issue in Trademark Law, organized by Patent, Copyright and Trademark Owners Association, Emerging Trend in Copyright, organized by the Ministry of HRD, Government of India, Faculty Development Program on Intellectual Property Rights, especially for the engineering faculty members, refresher course on intellectual property rights and human rights, WIPO SARC expert body workshop on intellectual property, traditional knowledge and genetic resources, conference on copyright enforcement, Symposium on WTO and its implications, and many more. Professor Ramakrishnan had authored number of modules for postgraduate diploma course on intellectual property rights, among which a few of them are Introduction and Basic Concept of Intellectual Property Rights, Acquisition and Enforcement of Intellectual Property Rights, Information Technology Related Intellectual Property Rights, Biotechnology Related Intellectual Property Rights. Professor Ramakrishnan is a brilliant researcher and had undertook various funded and non-funded research projects, uh, such as research for the Justice Malimat Committee on reform to the criminal justice system, which is well known to all the law fraternity members. Secondly, project on globalization and the international governance of modern biotechnology. IUCN project, working on a project sponsored by the IUN Bond on Intellectual Property Strategies for a successful biotech industry, worked with Government of Karnataka Labor Department on policy related child labor officers, investigating officers, etc. Government of India project on impact of outsourcing of clinical trials to India, and Ministry of HRD funded traditional knowledge protection. So this is not actually the end of his profile. If I go on saying, it will be a never-ending profile actually. And so with this lot of experience, we hope that we'll be learning a lot from him. So sir, I request you to take over the session.
Thank you, Prasenjit, for a very elaborate and then introduction of mine. Thank you very much. You were so generous. Let me at the outset thank Preeta and all the organizers of this particular program. It took off very well. I was there for the inaugural session, and Mr. Mohan Rao has set a benchmark for this particular program by wonderful analysis of different developments that happened. And there were different sessions that you had all over. I deliberately choose Sunday for the simple reason that we had series of programs lined up after the inauguration of this particular program. Sunday, of course, I can speak leisurely. Preeta asked me to speak on trademarks initially. Then I wrote back to her as to why you are choosing me for trademark. Then she gave me another list of topics. Then I saw that there are other speakers on other subjects, and I told Preeta, fine, let me just confine to whatever you have assigned initially, right? It doesn't matter which topic you're going to speak, right? As long as it is within the framework of the TRIPS, within the framework of IPR. So that is how I have chosen trademark law. I would just try to give you an overview of the trademark, as the title says. And when I move giving you the overview of the trademark, I might get a little deep into certain concepts wherever required, if time permits. Otherwise, it will be, in literal sense, an overview only, right? Kindly permit me to share with you the PowerPoint presentation. I hope this PowerPoint presentation will have definitely point as well as the power in it.
Yes.
Can you see that?
Yes, sir.
Yeah. So law of trademark. An overview. See, the title also says overview of the law of trademark. Let me just start my presentation with the functions of trademark. And so what are the functions of trademark? Before I move to the functions of trademark, I am interested in quoting Justice Frankfurter, who in the famous case of Mishawaka Rubber and Woolen Manufacturing Company versus SS Chris, he said, so what a trademark is. Trademark is a merchandising shortcut which induces a purchaser to select what he wants or what he has been led to believe he wants. So the purchaser, the consumer as you call it, he wants certain things and he has been led to believe that there are certain products which are good for him. So the trademark is a merchandising shortcut and that induces the purchaser to purchase it. See, look at it from the owner's perspective. The owner of a mark exploits this human propensity by making every effort to impregnate the atmosphere of the market with the drawing power of a congenial symbol. So the market here is impregnated, right, with this particular symbol. What is the symbol here? The protection of trademark is the lost recognition of the psychological function of the symbols. So the psychological function of symbol is that it takes you to a particular product, it takes you to a particular service, it takes you to a particular organization. See, the moment you see olive leaves, right, immediately you are reminded of peace and security. The moment you think of the bald eagle, you are reminded of United States. The moment you are looking at blind goddess, you are led to the scales of justice. So which means symbols have that particular power, the psychological function they have. And what you find in trademark is the psychological function of the symbols. Shakespeare, I am sure you might have read Romeo and Juliet. Through Juliet, he says, what is there in a name? By whatever name you call rose, right, it has the same fragrance. Whether you call it jasmine, whether you call it any name, but the rose will have its own fragrance. So that is what he was saying as to what is there in a name. Well, friends, that doesn't apply to the trademark law. There is everything in the name. There is everything in the logo that you're going to select for your product. And that's the power of the trademark. What are the functions of the trademark? The four functions of the trademark are: one is identification, second is source, third is quality, and the fourth, advertising symbol. These are the four functions of a trademark. Just have a look at each function. Number one is to identify one seller's goods and distinguish them from goods sold by others. Second one, to signify that all goods bearing the trademark come from or are controlled by a single source. Signify that all goods bearing trademark are of an equal level of quality. And finally, as a prime instrument in advertising and selling the goods. Let me just pick up one, the first one, identification. Trademark is an identifying symbol, fine. I have always told my students that there is a very, very simple way of understanding the trademark, and this has been acknowledged by the acknowledged writers in trademark law throughout the world. Just two questions. Who are you? What are you? Right? You just stand in front of your laptop and ask the question, who are you? What would be the answer that you're going to get? I'm sure it will say, I am HP, I am Apple, so on and so forth. Stand before a refrigerator and ask the question. Stand before the TV and ask the question, who are you? To all these, it will say Sony, etc., etc. Ask the question, what are you? It starts describing its nature. It says, I am a laptop with all these features. I am a TV with all these features. I am a refrigerator with all these features. Ask an individual only. Ask our host, who are you? She will say, I am Preeta Brahma. What are you? She starts explaining, sir, I am a professor, I am so and so, I have been organizing this program. Ask Prasanji also, he also would say, I am Prasanji. What is the difference, friends, here? These particular two questions.
Sorry for interruption.
Please. Yeah.
Sir, your slides are actually not moving.
Acha.
So we are just seeing law of trademark. The first slide.
Oh God. Yeah, you should have informed me. Yeah, 1 second. This you have not seen?
No, still it is the law of trademark only, the first slide, sir.
Surprising. This is what you are seeing.
Kindly enlarge it, and also.
Yeah, I have put it on the full.
Oh.
Yeah, is it moving now?
No, sir. No, sir.
Sir, if you can just put the arrow mark down, if you just click.
No. 1 second.
So
I'm going to share it again.
Yes, sir. Yes, sir.
It will be good.
Yes. No.
So now it's coming full screen, sir.
Yeah.
Yes, sir.
Yes, sir. Yes, sir.
Now?
Yes, sir. Yes, sir.
Yes,
It's
sir.
functions of trademark. Functions
Yeah.
of trademark, sir.
Now?
Functions of trademark. Yes, sir.
Yeah.
Yes, sir. Yes.
Now you can see this one.
Yes, Justice
This is-
Frankfurt.
Yeah, this is what I was trying to highlight in the beginning itself.
Yes.
Right? It's a merchandising shortcut. See how the psychological function of symbols function in the trademark era. And he said the protection of trademark is the law's recognition of the psychological function of the symbols. That is where I told you that the bald eagle, the blind goddess, the dove, see, these are the symbols. And I'll come to the symbols and the trademark law little later. So this is the importance of the symbols, and therefore both the consumer as well as the proprietor of the product would be able to gain through the trademark protection. And this is where I had moved to the 4 functions. I think you can see that. Prasanji, please coordinate with me
Yes, sir.
and keep telling me whenever it stops.
Okay, sir.
Yeah. Identification, source, quality, and advertising symbol. And this is what I was discussing now. Trademark answers the question, who are you? And not what are you? The moment the answer to the question, who are you, gets transformed to the answer to the question, what are you, it loses trademark. Or vice versa also. As long as it is answering the question, what are you, it would not become trademark. And the moment it starts answering the question, who are you, it gains the trademark status. What is that? That is called as acquisition of secondary meaning by a particular word. Now tomorrow, let me just pick up one particular name from the region, your region itself. Let me just pick up the surname of Preeta, Brahma. The moment you use the word Brahma, it might refer to Preeta Brahma or our Lord Brahma. Right? And now I just modify that particular thing and start production of a technical gadget. And the technical gadget now I would like to call it by the name Brahma, but with a suffix, not Brahma as is. Now people initially would say, this is the name of an individual, name of the God. But when the product is marketed, people start relating that particular name to the product and not to the Lord Brahma whenever the question of product comes up. Like Harley and Davidson. Harley is the name of an individual, Davidson is the name of an individual. Both of them come together. And today, if I ask you the question, Harley Davidson, I don't think any one of you would identify an individual, but identify the motorbike. There were 2 persons who friends in the engineering college. One, a dropout, a wealthy man, and another, a brilliant scholar. After 4 years after graduation, they meet on the streets of London and they exchange pleasantries. And inquire about each other. And the first person says, yeah, I was a brilliant man. I graduated with distinction, but I am not getting a good job that I deserve. And the second person says, I was not interested in continuing there, but I have so much money to invest. I do not know what to invest on. Both of them took a decision on that particular day and started a project. And after 4 years, rolled out a car, the most popular car in the world, Rolls-Royce. Rolls and Royce were friends. The names of these two persons have become the trademark, right? So like that, from what are you, it could become who are you. From who are you also, it can become what are you. For example, cellophane. Cellophane initially was the brand name for a particular product, but over a period of time, cellophane became a product's name, generic. Aspirin, I'm sure you have heard of aspirin. Aspirin was the name for a particular product, headache product manufactured by Bayer. But it became so integrated with the product itself that whenever there was a headache, people in America asked for aspirin, whether it's manufactured by Bayer or by any other person. So aspirin became generic, and it was Justice Learned Hand in the Supreme Court of US who declared and said, this is no more to be used as the trademark. So it became generic. Walkman has become generic. Dada has become generic. And see the fate of Xerox. What would happen to Xerox? Xerox was answering the question, who are you? And now ask any person, including the trademark office. They say, please submit 10 sets of Xerox copies to the office. Xerox cannot be used as photocopies. And Xerox has been trying to protect it. I'll come to that and explain you as I move on. So these are the things friends say. Who are you to be answered, and therefore product identification is the basic function of the trademark law. Trademark does not disclose the name of its owner, but it says that there is a common source. Similarly, source function also. Wherever the Pepsi-Cola bottle is bottled, it is done in different parts of our country, but the moment we purchase Coca-Cola, we say it has a common source, right? Even it would be anonymous sometimes. How many of us know as to what are the different products of Hindustan liver? We just purchase them. How many of us know that this is the company which manufactures all these different products? We just know by the name of the product itself. Similarly, the next one. Today, I have consumed a particular beverage, a soft drink I have consumed in Bangalore, imagine. And tomorrow I move to Guwahati. And in Guwahati, I want to have the same taste. I know the brand name. I go and ask for that particular product with the brand name. What is the felt quality? What is the expected quality? I would expect the same quality as I have felt when I drank it in Bangalore. What is the trademark what is the function that the trademark is serving here? Trademark is serving the function of consistency in the quality. If I buy that particular product of a particular brand, I am going to get the same quality which I have experienced now. So that is the quality function that the trademark serves. And next one is, it is an advertising symbol. Well, friends, with that, I am going to take you through a very interesting development, that is how the brand awareness happens. Initially, all of us know that there are hundreds and hundreds of brands. In fact, I was planning to take the entire audience through a quiz, a sort of quiz for 5 minutes, where I wanted you to identify certain brands with a particular product. But that would take a little time. Let me see if that happens at the end. We can try that and then involve all of you. So when you know there is brand awareness, but brand awareness is just awareness. How many of us would prefer all the brands that we have that are there? Next comes the high degree of brand acceptability. we will say that these are the brands which we would want to. Not all the brands that are there in the world. After that, see, I know about all the popular brands of car, but I also know my purse. I would not go for all the brands, right? I may be happy with whatever brand that I can afford to. See, the next one which comes here is there are brands that enjoy a high degree of brand preference, from awareness, acceptability, and then preference. Just ask some of the women about the perfume. They would say, we would not go for any other perfume other than X, Y, Z. I do not know what those X, Y, Z are, but X, Y, Z perfumes, they would say only this. If it is not available, nothing else. That is the last stage in the brand thing, and that is where the goodwill is generated. It is the brand loyalty. So people with brand loyalty are the people who are generating goodwill for a particular product. Then, friends, in the entire, before you understand the entire trademark law, I would say that you must know the spectrum of distinctiveness. This is the basic. If you are a teacher also, you should know this, and otherwise also you should know this particular spectrum of distinctiveness. We call it as Abercrombie test. Abercrombie test, developed in US. What is Abercrombie test? It's the spectrum of distinctiveness. Marks are divided into three categories. One is inherently distinctive mark, second, non-inherently distinctive mark, and the third one, mark without any distinctiveness. This is particularly applicable to the word mark. First case, marks which are inherently distinctive. There is no need for any secondary meaning, which means those marks automatically qualify for protection as a trademark. They become trademarks. Second one, non-inherently distinctive marks. They're not inherently distinctive, but they qualify for the trademark by acquiring the secondary meaning. The third category is mark with no trademark significance, the generic mark. The generic mark will never become a trademark. Something like calling laptop a laptop, calling bottle a bottle, calling fridge a fridge would never become a trademark. Let me just come to the first part of it. Inherently distinctive marks. There are three categories that have been recognized here: fanciful marks, arbitrary marks, and suggestive marks. Fanciful marks. What are fanciful marks? Fanciful marks are marks which are created exclusively for the purpose of being used on a particular product. They're created for that purpose and they become fanciful marks. Fanciful marks are always invented marks or words which are not in common use. I have given you a list of marks here: Kodak, Cuticura, Cutex, Orgaril, Cortex, Odal, Polaroid. They were all created or invented for the purpose of being used with respect to those products. But there is, as I told you, danger with these fanciful marks also, right? What is the danger? The danger is they get associated with the product so intimately that it might lose the trademark status over a period of time. I was telling you about Xerox. I just wanted you to watch this. See how Xerox is trying to safeguard its own trademark. It says, you can't Xerox on a Xerox. But we don't mind at all if you copy a copy on a Xerox copier. In fact, we prefer it because the Xerox trademark should only identify products made by us, like Xerox copiers, printers, fax machines, software, and multifunctional machines. As a trademark, the term Xerox should always be used as an adjective followed by whatever it is, right? So which means you shall not use it as a Xerox. You use it as a photocopying on Xerox photocopier. Retain that. And there is one more advertisement, very interesting advertisement that comes up from Xerox. Xerox says, I told you about aspirin, right? Aspirin is generic. And Xerox comes out with an advertisement saying that please do not use the word Xerox in the same way you use aspirin. The next part is very interesting. It says, if you use the word Xerox in the same way you use aspirin, we get headache. Right? So through that, they're trying to retain the trademark status for their product. Well, friends, arbitrary marks are there. Arbitrary marks are marks which have primary meaning, like Vidhyarthi Bhavan, like cycle, 7 o'clock, or apple. They all have the primary meaning. But when applied to the product, they are applied arbitrarily in the sense they do not have any connection with the nature of the product. Those are arbitrary marks. They also qualify for trademark, and they are the marks which are inherently distinctive. Like the example that I have given here, apple, black and white, ice cream, mountain, camel, and shell. Well, friends, suggestive marks is an interesting mark. In case of suggestive marks, these are the examples, but I'll go and explain you as I proceed. Suggestive marks are marks where the consumer will not be able to relate it directly to the product, but there needs a little bit of imagination, and then he will be able to identify that with the product, not directly. And those suggestive marks are also considered to be inherently distinctive marks. Can you just make out what this particular thing is? You see the hound, right? And the shoes. It's called as hush puppies. Why did it become hush puppies? What is the background for that? When I ask this particular question, people say, yes, sir, see the smoothness of that particular dog, and the shoes are also as smooth as the dog is. And therefore, it should be called as hush puppies. But very interesting background is there. I'm going to show you that particular interesting background now. Just see here. It's a slice of Americana. There was a new but unnamed line of men's and women's comfortable shoes made by Wolverine Company. They did not have any specific name for that. And it was Jim Muir who was given the responsibility of finding a name for that. He was traveling in Tennessee. And when he was traveling in Tennessee, he was asked by his friend to accompany him for dinner. It was a catfish dinner. Along with catfish, the friend served hush puppies. Fried cornmeal duff balls. These were called as hush puppies. And the friend was very, very curious. I keep telling, this is a sales manager. You know the functions of a sales manager, qualities of a sales manager. Sales manager should be one who should be able to sell a comb to a bald man, right? This Jim Muir was a very, very talkative man. He was so talkative that he did not stop even when he was having his catfish dinner, and he kept on asking. He asked his friend, why do you call it hush puppies? His friend was very, very hesitant. You know why he was hesitant? Because this man is so talkative. And just see here, you'll understand as to why he was hesitant when you look at the answer. He said, why hush puppies? Farmers use them to quiet their barking dogs. Was this friend Jim Muir barking at that particular time? No. This Jim Muir jumped with joy and said, well, I have found a name for my shoes. The expression barking dogs was used for tired, sore feet in America. This is also an idiom in English. And that is when this particular product became hush puppies. Why hush puppies? If those hush puppies are for the barking dogs, for the tired, sore feet, our shoes. And therefore it became hush puppies. And that is a suggestive mark, friends. Suggestive marks are as inherently distinctive as the arbitrary marks and fanciful marks are. These are some of the examples for suggestive marks. IHOP, DQ, Grill and Chill, or Crayola for crayons. And I was telling you as to what have become generic and what are likely to become generic. Kerosene is no more a trademark. Aspirin is no more a trademark. Xerox might see that particular end if it does not contain the genericide. The last one is the descriptive marks. Descriptive mark, for example, cafe. Cafe is a descriptive mark. Coffee is a descriptive mark. Day is a descriptive mark. But today, if you ask about cafe coffee day, I don't think anyone would describe it in the giving it the primary meaning. They would straight away refer to the coffee day as a trademark, right? Bikaner is a place, but Bikanerwala has become a trademark. So like that, these descriptive marks are capable of becoming trademarks when they acquire the secondary meaning. Generic terms can never become trademark. The names of the product itself is antithesis of the mark. So the terms generic and trademark are mutually exclusive. Why they should be excluded? The answer is a public policy one. Generic names are regarded by the law to be free for use. All of us should use that. Right? These are some of the names of the generic one, which can never become a trademark. Well, friends, to conclude this particular part, an apple for computers is arbitrary. Apple a day for vitamin tablets becomes suggestive. Tom apple for combination of tomato and apple juice is descriptive. And the last one, apple for apple, is generic. This is briefly about the spectrum of distinctiveness. Let me just tell you as to what's the definition of a trademark, and then I'll take you through other interesting part. What is a trademark? How is it defined in the Trademark Act? See, this is the definition of a trademark. A mark capable of being represented graphically and capable of distinguishing the goods or services of one person from those of others. So basically, it should be a mark. It should be capable of being represented graphically, and two, capable of distinguishing the goods or services of one person from others. I have already referred to the second part, distinctiveness. I have already referred to that. The first one is it should be capable of being represented graphically. And there, the problem comes with respect to non-traditional marks. I'm going to explain you as a progress. And it includes shape of goods, their packaging, and combination of colors. So what is a mark? I'm just going to explain as what a mark is. Device or a pictorial representation becomes the mark. All these are examples of device or a pictorial representation. Then a label can become a trademark. These are all examples of labels. A ticket can become a trademark. A ticket is something which is loosely attached to the product. It can become a trademark. Levis is an example for a ticket. Not the name, the word here, but the way it is attached to the product. It's also a trademark. Then comes the question, can there be a name becoming a trademark? Yes, in 99% of the cases, it's the name of individual as a company or a firm which has become the trademark. Kirloskar, Tata, Maruti Suzuki, Harley Davidson, Cadbury, so on and so forth. All of them are names. Rolls-Royce, Avery, Murati, Kirloskar, Harley Davidson, Cadbury, they're all, and Nilgiris is the name of a place, also has become a trademark. Signature can become a trademark. These are examples of signature becoming a trademark. And invented words, these are some of them are invented words like Bovril, Whiskier, Metmas, Dustic, etc. But tonic preparations for Livron for tonic preparations considered to be not invented. Pusikin for cats, not invented. Insti for instant teeth, not invented. There are descriptive marks. For example, Sappho. Sappho for cleaning powder, or Satinin for laundry launch, starch, can never become a trademark. The name of a person, place, or things, I have already given you examples for that. Personal name, these are the examples, Haldiram, Hershey, etc. Letters can become trademark, like K, M for McDonald, so on and so forth. They all are trademarks. Numeral also can become a trademark. Well, these are examples for letter becoming trademark. And shape of goods, packaging, combination of colors, and combination thereof. This is what a mark means, friends. Well, with that, Before us, there's a question. I'm sure I must deal with this also as I progress. Can sound be a trademark? Can smell be a trademark? Can color become a trademark? Can shape become a trademark? Or motion images become trademark or not? These are the examples here. Let me just pick up the first question as to whether a sound can become a trademark at all. Friends, please listen to the sound if you can hear them and identify. If anyone can identify quickly, you can respond. I'm putting it again, beginning. I'm sure you will not respond. See, this is Anheuser. Yeah. This is AT&T.
Hey man, who's that cat coming down the street?
I don't know.
A full song.
Like that's Wicked Man with the bone.
Sure having himself a ball.
Presently, can you hear?
Yes, sir.
Yeah. This is for Harlem Globetrotters. I am sure the entire audience will be able to identify this. Intel. Yeah. This is MGM Roar of the Lion. Nokia. Yeah. What is this? This is Pillsbury. Twentieth century pop. Yeah, see, for if you're going to describe that by name, you face the problem. I don't know how many of you will be able to identify the sound mark with this particular description. Semi-long sound in the chest, register, etc., etc. But the easiest way to identify them is through the sound itself. This is the Tarzan yell. Yeah, somehow it is not working. Harley Davidson, right? The sound of Harley Davidson was claimed as a trademark. It gives a sound, potato, 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 some sound. And that was claimed by describing the mark in this particular way. They said the mark consists of exhaust sound of applications of motorcycles, products produced by V-twin common cramping engine. And Joseph Bonk, the HD attorney, he describes it in this way. Design results in a syncopated, uneven idle which, when simulated verbally, sounds like potato, potato, potato. My friends, the question before us is, does it become a trademark? Right? These are the things to be satisfied here. Number one, it should be a symbol. Number two, it should acquire a secondary meaning. Number three, it should overcome functionality doctrine. Only then it can qualify as a trademark. And in this particular case, the Harley Davidson, if compared with Honda Shadow, this has been compared actually, and the sounds, right, are so distinct in these cases that people who have heard and admire Harley Davidson sound would not confuse it with the Honda Shadow. However, if people are blindfolded and asked to identify a particular sound, and if they say for every good sound, if they say it is Harley Davidson, then it is the name which has become popular and not the sound which has become popular. Now, after this, we applied this particular test to find out whether a description is a symbol or not, acquires secondary meaning or not. Now we find that the exhaust sound is not a fixed sound and therefore cannot become a symbol. Assuming again that it is given in MP3 form, then it becomes a symbol. Then has it acquired secondary meaning? Yes, it would acquire secondary meaning if consumers blindfolded are going to identify Harley sound and distinguish that from Honda sound or any other sound. If not, it does not acquire secondary meaning and therefore it does not pass the second test. Even if it passes that particular second test, assume for a minute, how is this particular sound produced? The sound is produced because of the function of V-twin common crank pin engine design. And this is the functional part of the whole bike. And if you're giving protection for the sound, exhaust sound, you're giving protection for the technology as such. So people cannot circumvent the IPRs to get another IPR. This particular sound would not be entitled for any trademark protection. How are you going to represent this particular trademark? Friends, if law students can just go to Shield Mark versus Juice Kist case decided by the European Court of Justice, and the sixth chamber concluded by saying that when you indicate that in the form of a sign consisting of notes, it will not become a graphical representation. Indications of the cry of an animal will not become a graphical representation. By onomatopoeia, without more, it will not become graphical representation. Even sequence of musical notes is not sufficient graphical representation. And they said that the only mode of graphical representation could be, right, by stave divided into measures and showing in particular clef, musical notes, etc., etc. You know, those staves, 4 lines are there, and then there are clefs in each of those particular measures, and that is a mode of representation which can qualify for protection of that particular mark. Well, friends, can color become trademark or not? Let me just quickly go through this particular thing. T-Mobile trademarks the color magenta. They have got trademark for that. However, not all color trademarks would become trademarks. In this particular case, the red and white stripes for toothpaste was not allowed because they said red stripes are functional in that they carried the mouthwash in the product. And red was the only limited number of colors available here. And in case of John Wyeth color tablet, a single color was being applied to the whole surface of the drug to indicate its strength. Strength here, friends, please note here. Color in this case has been used to denote dosage rather than as a trademark. The colors yellow and blue were common in the pharmaceutical industry and could not acquire secondary meaning. For example, if you just say red tablets contain 5 mg and blue tablets would contain 15 mg. So red tablets and blue tablets, the color red and blue here are indicating the dosage and not indicating the source. Therefore, they would not become trademarks. And the European Court of Justice has examined in Heidelberger case, right, as to how a color would become trademark. And see on the right side what I have written here, a color combination which has not been spatially delimited is not registrable trademark because it is not sufficiently precise that competitors can see from the register exactly what is protected. If you just say 2 colors and you have not spatially demarcated as to how much is this color, how much is that particular color, then it is a very wide protection and therefore would not be entitled for any trademark protection is what the European Court of Justice said. Red lacquered sole of Christian Louboutin shoes are protected here. This is the color which is protected. Owens Corning's pink insulation it has got trademark protection. See here, the next is, the entire thing is Owens Corning. Again, the pink is their, and even the Citigroup Bank also gets protection through that particular wave, blue and red wave. Then friends, the question is, can shape become trademark or not? Shape can become trademark. See, the contrary bottle shape is protected, Coke bottle is protected, Jif lemon is protected, Toblerone chocolate bar, which you eat, is protected. But shape will not be registered if it results from the nature of the product themselves. For example, you claim for round shape of a tennis ball, that will not get protection. Or a shape which has got the technical result, like the example that I'm going to give you now. Substantial value of goods, all these three would not become trademarks. See here, this is the shape of the Philips shaver. Philips shaver had this particular shape, an equilateral triangle, and within that you find 3 circles. And these 3 circles are going to perform the function of effective shaving. This particular shape was claimed by Philips, and Remington manufactured a similar product, and there was a suit against Remington which goes ultimately before the European Court of Justice. Philips versus Remington. And the European Court of Justice addresses 4 questions, of which the 4th question at this particular stage would be relevant for our purpose. What is the 4th question? Whether a purely functional shape is caught by the exclusion, even where it could have been shown that the same technical result could have been achieved by other shapes also. See here you have equilateral triangle, 3 circular rings. Imagine in front of 3 circular rings placed in each angle, if there are 3 circular rings, one inside the other, right, ingrained like that, there's a different shape. When there's a different shape, should not this particular shape claimed by Philips become distinctive? To that, categorically ECJ answered in this form. It says, it must be interpreted to mean that a sign consisting exclusively of the shape of a product is unregisterable by virtue of thereof if it is established that the essential function features of that shape are attributable only to the technical result. So you have a shape, and that shape results in technical function. That's enough. It's an absolute bar. And the moment it results in technical result, that shape would get excluded from trademark protection. An interesting one. An application was filed for shape relating to sweet on sticks. You know, lollipops are they? Something like that. Relating to sweet on sticks. And the trademark office said, no, we can't grant it because it's entirely functional. What is that function? It assists the consumer to eat the product with minimum of mess. When I say mess, I'm sure you must have seen the advertisements of Cadbury, right? Mess all over the mouth and other places. So this assists in eating the product with minimum of mess. And therefore it is functional, cannot get the trademark protection. In India, we have granted protection for shape of Zippo lighter, right? Friends, I think smell I would just skip and then move forward. What is the procedure for registration of trademark in India? And through that, I'm going to explain you some of the substantive parts of grounds for refusal of trademark. Simple process that I have explained you here is an application is filed, receipts are there. Now it's all online applications. Application number allotment happens and the data entry happens, and there'll be scanning for that particular thing. Then examinations will happen. Examination report is dispatched, and it's either accepted or objected to. If it's accepted, then the procedure follows. If it's objected, then the person will be asked to show cause, right? If it is refused, then there's appeal before the Intellectual Property Appellate Board. If it is accepted, see, it will be published in the journal, and then they await opposition. And if the opposition is there, then there will be a board constituted for hearing the opposition, and if the opposition is discarded, then the application would be accepted for registration. It goes for registration process. If the opposition is upheld, then it could be appealed against, right? Either review or appeal against the Intellectual Property Board. This is very, very simple way, and latest changes to the trademark rules have indicated that out of so many forms, there were more than 70 forms, they have been reduced into minimum number of forms now, right? That's briefly, friends, about the procedure. I would not spend more time on the procedure part. Well, friends, when application is filed and the examination happens, there are grounds on which trademark could be refused. And here we look into some of the law, right, which has substantive impact on that. What is that ground on which you're going to refuse registration? First ground is that it is not distinctive in nature. What is devoid of distinctiveness? Like simple signs, simple letters, simple numbers, grammatical signs, or a line, square, or a diamond, or a circle. If it is just that without any idiosyncratic combination, it is devoid of distinctive character and may be refused. Then, if it is descriptive in nature, for example, it indicates the kind of goods, quality of goods, intended purpose, value, geographical origin, time of production, or other characteristics of goods. For example, now, kind, quality, and quantity. You want to use the word extra large or small, right? Don't mistake this for certain products. Extra large, large or small, this cannot be a trademark. Good or best, 20 or 200 in a pack of cigarettes cannot be trademark. Treat for dessert sauces or Fruit Loop for cereals cannot be trademark because that indicates the quality. See, the lasting performance for perfumes. Perfumes are meant to have a lasting performance, and that would not become a trademark which is descriptive. And if it's intended purpose, some of the examples here are perfect bro for cosmetics. This is descriptive. Food saver for vacuum packing machine, descriptive. Kettle clean for preparations of cleaning kettles, descriptive. Slim and fit for slimming preparations, descriptive. And if it is value, then if you just say 2 for 1, worth their weight in gold, these cannot become trademark because they're describing the value of the product. Similarly, geographical names cannot become trademark. There are exceptions to that. Maybe we can take up during the question asked. Magnolia for metallic permitted. Farah for cloth were permitted. However, the word Shimla, very interesting case between ITC and the trademark office, which went up to Calcutta division bench, where the court said categorically that the word Shimla cannot be used with respect to cigarettes manufactured by the ITC. One of the argument, I'm not into all the argument. One of the argument here was, well, it was a counter argument to an argument which said nobody would grow tobacco in Shimla because you can't grow tobacco in Shimla, and therefore this should become arbitrary and we should be permitted to use it. But the response here was, the counter argument was, nobody can grow tobacco, but anyone can process tobacco in Shimla. Right? And therefore the name of a popular place cannot be used. Mediterranean for transport services cannot be used. Wall Street, Dalal Street for financial services will become descriptive. Well, friends, exceptions could be they can acquire distinctiveness and acquire secondary meaning. When they acquire secondary meaning, they might displace the primary meaning as well, or they may not displace the primary meaning. But you're going to look at the relevant class of persons to find out whether it is acquired distinctiveness or not. Well, friends, other absolute grounds are, if it's going to deceive the public, I'm going to give you examples now. If it's going to deceive the public or cause confusion, or if it hurts the religious susceptibilities, or if it is scandalous or obscene, or if it is prohibited by Emblems and Names Act. These are the grounds on which it can be refused registration. Let me just refer to you one specific case, very interesting case, Amrutdhara Pharmacy and Satyadev Gupta. And this is a leading case, the principles of which is still followed, adhered as a precedent. Simple issue was just like this. Satyadev Gupta filed an application for registration of what is called as Lakshman Dhara, right? And Amrutdhara Pharmacy had established itself right from 1903 and was selling this particular product under the name Amrutdhara. The application with Satyadev Gupta goes around 1949 or 50. Amrutdhara Pharmacy raised objection saying that there's a confusion between Amrutdhara and Lakshman Dhara. Trademark Office says, yes, we find some confusion because the consumer is likely to get confused when he goes for a particular product. Similar products were there, sold under these two names. And then they go before the Calcutta High Court. Calcutta High Court judges were not convinced with the decision of the Trademark Office. The Calcutta High Court judges said, well, where is the confusion? The two words, see Amrutha, see Lakshmana. And they started dissecting or dissecting this particular word Amrutha, going back to Samudra Manthana and the creation of Amrutha and how the whole thing happened. And people are very much aware of Amrutha. And similarly, they will go to Lakshmana and then say, Lakshmana is a warrior, right? In Ramayana, he is known for his strength, valor. And this is Amrutha and this is Lakshmana. There is no question of confusion. Registrar, you register it. Amrutdhara Pharmacy approached the Supreme Court. So the Supreme Court had to examine this. Some questions, one of the questions was, who are the persons who the resemblance would be likely to deceive or confuse? To whom should it cause confusion? See, I have stomach pain as a consumer, or a common man has stomach pain. He wants Amrutdhara. He goes to the shop and asks the shopkeeper, Mujhe Amrutdhara dijiye. And the shopkeeper may not have Amrutdhara, he may have bought Lakshman Dhara. He says, Kya Lakshman Dhara chalega? Imagine the position of that person before the shop asking for Amrutdhara because of stomach pain. Do you think that person would now start going back to Samudra Manthana, Amrutha, going back to Ramayana, Lakshmana, and then say, this is confusing. There's no confusion between the two. The moment the person hears Amrutdhara and says Lakshman Dhara chalega, whether he gets confused or not, who is that person who is going to get confused? If the person says, Mujhe malum nahi, koi dhara chalega. If he just says that, then the thing is he got confused. Who is that person? What is the standard here? And that standard has been laid down by the Supreme Court in this particular case. What is that standard, friends? That standard is, you should look at it from the point of view of an unwary purchaser with average intelligence and imperfect recollection. An unwary purchaser with average intelligence and imperfect recollection. You cannot apply the standard of an intelligent person and a person with photographic memory, and that will not be applicable to decide deceptive similarity. And these tests, friends, have been reiterated by the, I see present G. They've been reiterated by the courts all through, and that is a test. And in this particular case, since the purchaser will not split the terms into component parts and consider etymological meaning, there is confusion in between the two. And the next one was, what rules of comparison are to be adopted in judging whether such resemblances exist? The court says, overall structural and phonetic similarity of the two terms will have to be looked into. The trademark as a whole needs to be considered and should not be split into different parts to find out the etymological meaning of each part of it. So this is the test to be applied. And by applying this test, if you find that it is likely to deceive or likely to cause confusion, then such a trademark should not be given registration. I'll just refer to one or two points on this particular section 9, and then we'll take a break, and after the break we'll come back and then continue. Right? Let me just stop at an appropriate place. In Hoffman-La Roche, it was a medicinal product, Dropovit and Protovit, the court says there's no confusion because Dropovit and Protovit are two different things, because white is common, whereas the first one, Dropo and Proto, they're for two different products, and therefore there's no confusion whatsoever. And in Dyer Meakins Brewery's case, Highland Chief plus device of a Scottish soldier wearing feather bonnet. You have not used the word Scotch whiskey, but you have used the symbol of Highland Chief that refers to Scotch Whisky Association. That is enough to cause confusion, is what the court said. Hurting religious susceptibilities, hallelujah, right? If you use the word hallelujah, which means praise the Lord, song of praise to the God, was refused registration. And then, friends, let me just give an interesting part of the whole development. See here, Jardex is already there. Jardex, they want to register as trademark for disinfectant. And Jardex for extract of meals is already in use as a trademark. Just imagine there is no confusion, but both are likely to be used in the hospitals. Imagine a nurse has been asked to bring, right, Jardex, second Jardex, the extract of meal for a particular patient, and the nurse brings the first one and administers it to the patient. The disinfectant would kill the patient in that particular thing. So it is refused. And in India, very interesting happened. Nardaline for stimulant. They wanted registration for Nardaline. You don't pronounce it as Nardalzine, Nardaline. And the second one is Nardil. Nardaline for stimulant. Already Nardil for depressant is already registered. Again, look at the hospitals where people are treated. A person who is volatile, right, who has become mad, has been taken to the hospital. He is so volatile that he will have to be contained. And now if Nardil is to be given to him as depressant, and imagine in that particular stage if Nardaline is given, he would, right, just die. And look at a person who is also already going to coma, and he needs a stimulant, Nardaline he needs. And if he's given Nardil, depressed person would further depress from coma, he go to a different world altogether. So what is the problem here? The problem is that it's like if there's a slight confusion, it is likely to lead to disastrous consequence. It's called as disastrous consequence test, and therefore it is to be refused. In both the cases, they were refused. Last part of the section 9 is Emblems and Names Prevention Act has excluded all these. You can't use any one of these. You can't have a trademark in the name of Mahatma Gandhi at the parliament, or Ashoka Chakra, or Rashtrapati Bhavan, Raj Bhavan, Bharat Scouts, Sri Sharada Math, right, ICAO, Interpol, or any other international organization, or even the names of the international non-proprietary names. You know, recent case in the COVID context, I'll just state this and then they will take a break. In the COVID context, I'm sure you must have heard of Gilead Life Sciences. Gilead Life Sciences has patent over several products. And one of the products over which it has patent is Remdesivir. Remdesivir is considered to be one of the effective drug now at some stage of the treatment for COVID-19. And they have patent from 2015 up to 2035, they have patent protection for that particular product. Now, can they take trademark protection for the word Remdesivir? Remdesivir is a name given by the WHO as an international non-proprietary name to identify that particular chemical substance. Even Gilead cannot take trademark over that. Any other person who manufactures can have another trademark, but Remdesivir is sold as Remdesivir under different trademark. That's the thing. And that is what is excluded under these provisions. Well, friends, this is first part of it. What are the other interesting part is likelihood of confusion, and then dilution part I'm going to take up in the second half. With the permission of Prasenji, Ji, shall we take a break, Prasenji? Ji?
Sir, definitely.
Yeah.
We can go for 10 minutes, sir.
Yeah.
So it's 11:41, so we'll be meeting at 11:51.
Yeah, fine.
Participants, please don't leave the meeting. Otherwise, it will be very difficult for us to rejoin you.
Yes, Prita.
Yeah, we can resume back, I think.
Yeah, sure.
Yeah.
Yeah, friends, the first set of exclusions that I refer to, they're all absolute grounds on which trademark could be refused. What I'm going to refer now, what is that? What you find on the slides? I just displayed that even before I started so that you'll be familiar with this. There are two aspects here. One is about the likelihood of confusion, right? And the second one is about unfair advantage or detrimental to distinctive character of repute or the repute of the trademark. So these are the two things. First one is a case relating to likelihood of confusion test, as we popularly call it. And the second one is the one which has been introduced through the 1999 amendment, that is popularly called as the dilution doctrine that developed in US through the Federal Trademark Dilution Act. Although this particular concept had developed much earlier, way back in 1923 itself, in an article written by Shetter in one of the journals. And Shetter had borrowed this particular idea from development that happened in Germany, which means Germany already had this particular dilution doctrine applied. And you find almost 100 years have passed after that. And we find that reflected in our legislation. What is the dilution doctrine, how it's applied, etc.? Very, very briefly, I'm going to explain it because this forum, I don't think I'll be able to get into the nitty-gritties of each of these principles and the concepts. First one is, say, identity of earlier mark, similarity of goods or services, similarity of earlier mark, and identity of similarity of the goods or services, which means there is identical or similar marks and there is identical and similar goods or services, on the other hand. And by virtue of that, there is likelihood of confusion on the part of the public. Look at the second one. Second one, marks are identical or similar, but goods or services are dissimilar goods. They are different goods or different services. Under the Trademark Act, you have different classes of goods and services under which you will have to register your trademark. And you will be able to claim protection for your trademark if similar trademarks or considered similar trademarks are used with respect to those goods coming under that particular class. If you look at the second part here, even if people want to register it for a different goods or different services than what you have registered, if your earlier mark has become a well-known mark, then you will be able to prevent registration of that particular mark even for dissimilar goods or dissimilar services. I just would like to pick up here the infringement section, also section 29(4) also refers to this particular dilution doctrine. So if a person is using a particular mark for a certain goods or services, and this particular use of goods or trademark for goods or services is resulting in they taking unfair advantage of the well-known trademark which is registered in India, or which is detrimental to distinctive character of repute of that particular well-known mark, then it amounts to infringement, and such infringement is infringement by dilution. Similarly, if subsequently an individual uses a particular mark which is likely to cause confusion with the earlier marks, then also it amounts to infringement. So those two aspects I'm going to cover in this particular part itself simultaneously. Similarity of marks, some of the examples I'm going to give you here. You're going to look into the degree of phonetic, visual, or conceptual similarity. Always you look at the distinctive and dominant component. You're going to compare it with the distinctive and dominant component. Just have a look at the examples, right? Sometimes you give importance to first syllable, Beck and Eisenbeck. Sometimes you give importance to the idea underlying that, the concept underlying that. Zinc bar and Zn. Zinc and Zn, they mean the same thing conceptually, though literally they may not. So conceptually they mean the same, and therefore there could be similarity at the conceptual level as well. Even that will have to be decided while determining likelihood of confusion. Cadila healthcare case is one of the popular cases, the most important case in the entire development, and it was a case where falsi code and falsi type was there. And this test laid down by previous courts have been reiterated, and Cadillac case establishes or re-establishes the procedure to be followed when case of infringement comes. First impression is always to be judged, and manner of average implicit imperfect election laid down by Satyadev Amrutdhara Pharmacy is applicable. Burden of proof is always on the plaintiff. Durgadatt Sharma's test is applied. And Diachem case was overruled by this particular court. Simple reason is Diachem case where the case was between picnic and picnic, PIC, NIC and PIK, NIK. There was a logo of a person standing with a hat, a boy standing with a hat in between PIC and NIC. And that was not present in the second one. And the court went ahead and said, look at the dissimilarities. If the dissimilarities are so much which can separate each one of them, then it should not be held as deceptive similarity. That was in Diachem case. And in Diachem case, we also went ahead and said, there is no need for you to emphasize on the phonetic similarity. Cadila healthcare case overruled that and then said, Diachem case is a very bad decision. And we now lay down the principle. The principle is first impression, manner of average intelligence, burden is on the plaintiff, and you're going to look at the similarities between the two and the dominant features between the two to determine the deceptive similarity. And phonetic similarity is equally important as much as visual and conceptual similarity is, which cannot be ignored. And the most interesting part is the argument was taken up saying that physicians and surgeons are knowledgeable. But quoting McCarthy, the court said they may be knowledgeable in their fields, does not mean they are equally knowledgeable as to marks. And that does not mean that they are not going to mistake one mark for another. If you medicinal product, there should be much care to be taken here. The reason is medicinal products are drugs are poisons and not sweets. If for eating jamun, if you eat jangir, nothing will happen. If for eating X feet, if you eat Y feet because of the confusion, nothing would happen. But as I told you in the previous class, right, for taking stimulant, if you're given depressant, it damages the life itself. And therefore, there should be more care taken in such circumstances. The court laid down the factors to be considered for determining deceptive similarities. And friends, usually the highly distinctive, the earlier mark is, later mark will have to make minor modifications to change and become distinctive. I'm just picking up one particular example here. Vicks Vapor Up, who does not know Vicks Vapor Up? Vicks Vapor Up Salve and a triangle with words Vicks chemical company printed on that. The respondent here or the defendant here also manufactured jars of ointment. It was jars of ointment. And they use the word Cursot. Cursot is not Vicks here, but they use the word Vapor Up also, right? And the only word that I have used is Vapor Up. When they were sued, they took up the defense saying that Vapor Up is a descriptive word. However, the court overruled that. And only there are other parts like Cursot and other things which distinguish from Vicks. Still, the court went ahead and said the earlier mark Vicks and Vapor Up. The Vicks was associated with Vapor Up and Vapor Up associated with Vicks, and it's so much distinctive, which has caught the attention of the consumers, that use of the word Vapor Up along with any other word is likely to cause confusion with the Vicks Vapor Up itself, and therefore they granted relief to Vic Chemical. Well, friends, just have a look at some of the examples that I'm going to give here, like Rolls Royce of lawn mowers. Lawn mowers, they are manufacturing lawn mowers, and they say this is Rolls Royce of lawn mowers, our product. Or next to Marks and Spencer's, someone in Guwahati manufactures a bike and then calls it by a particular name, Prasanji Bikes, imagine. But when the advertisement they say, well, this is Rolls Royce of Guwahati. This is Harley Davidson of Guwahati. Can the word Harley Davidson be used or associated with the bike manufactured in Guwahati? That is where, friends, this particular taking undue advantage comes up. I have given you two examples here. Before that, just see here, no one can have a free ride. There must be a conceptual connection between reputation and the goods in respect of which the mark is used. The bike is there, Harley Davidson word you are using, and easily it gets transferred, and therefore it amounts to taking undue advantage. Selling drinks in football boot-shaped bottle with a three-stripe mark was there. And three-stripe mark, as you know, refers Adidas. And Adidas raises objection here. And they were able to say the drinks are provided right in these bottles, which is having the boot shape or football boot. There's a sporting connection, number one. And the connection in trade between the parties results in parasitic use of Adidas. And hence, this is taking undue advantage. However, in the second one, they said the reputation of Audi cannot be transferred to high technology ear, hearing aids. And therefore, they said there is no question of undue advantage being taken. Look at this particular thing. This is the most interesting part, where the mark is used on poor quality or ineffective goods. Clarin here is registered for gin. And someone wants to use the word clarin in a modified way for detergent. And the court says here, no one likes to be reminded of a detergent when drinking their favorite tipple reputation. Let me just give you an example here out of this. This is just an example, few assumptions you'll have to make. Maggie. The moment I use the word Maggie, what comes to your mind? I'm sure noodles come to your mind. And as we progress now, 12:30 or the break, perhaps you take noodles and then have 2 minutes noodle, then you may be eating also. So Maggie reminds us of noodle. Assume for a minute that Maggie has become a well-known mark. It's said to become, but assume it has become a well-known mark. And tomorrow there is an application filed before the trademark office, or there is already a person who is using that particular name for selling his product. What are the product for which registration is sought? Product which is being sold? Imagine, friends, if the product for which they want to use the word Maggie is not for noodles, but for toilet cleaning powder. Just think of it. When you are taking Maggie noodles, trying to eat that, you are reminded of the other Maggie. That is where it tarnishes the image of Maggie. That is what I meant here, tarnishment. It tarnishes the image of Maggie, and such a use of Maggie for different goods is prohibited by the trademark law. Right? That is tarnishment. I'll give you another example here of what happened in UK. Someone wanted to register the word visa. They applied for visa. This is not visa for going to any other country. Now, of course, we can't go. This is not visa, financial cards, financial services, but they wanted registration for the condoms. And the trademark office says, what is this? You're using it for condoms. We can't give you permission for that. We can't impose a burden on Visa International to educate its consumers saying that we have nothing to do with sexual hygiene. So it's going to tarnish the image of Visa, and therefore we are not going to register this particular thing. In India, it happened once, even before we amended our legislation. Haibo Hindustan. Haibo Hindustan is part of VIP. You know VIP. It started manufacturing certain goods and started using the word Benz. Benz, very boldly, it used the word Benz, and it used a human being, three-pointed human being standing like this with legs apart in a circle. If you have seen the mark of Benz, Benz is three-pointed stars in a circle, and the word Benz. Benz sued them for infringement. You know the defense taken up by VIP or Haibo Hindustan. It says the grounds of infringement should be likelihood of confusion. Where is confusion here? What do you mean? No Indian would think that this German company manufacturing cars in Germany the luxury cars in Germany, is coming all the way to India to manufacture undergarments. Who will confuse that? Therefore, there is no confusion whatsoever. However, the court was categorical in saying that the word Benz has acquired distinctiveness and a very high reputation here. Using this particular mark on unsavory goods like undergarments is likely to tarnish the image and reputation of Benz, and therefore this shall not be used anymore. So the dilution doctrine has been applied. So dilution doctrine is an important doctrine that's being applied even while rejecting an application as well as while determining infringement. That's the point at which I wanted to make. And then Trademark Office has done it on several occasions. Well, friends, let me just procedure I have already indicated. In case of infringement, I have already told you the two examples. And even when the mark is used as a trading style or trading symbol, it also amounts to infringement. And the most interesting part is when you use it in advertisement, especially when you use other trademark in the advertisement and compare the other trademark to a comparative advertisement, these problems are likely to result. I'll just give you, I'm sorry, can you just wait for a minute, please?
Yes.
Please have a look at this particular advertisement. This is case of comparative advertisement.
Following never before seen commercials were never aired due to their vicious nature and slanderous content. No audience has ever been allowed to witness these ads until now.
Drink Coke. It's the best. It's the best.
Hey man, have you heard about the new thing Coca-Cola's doing? You haven't heard? Well, dude, you're not gonna believe this. Every time you take a sip of the new Coca-Cola,
travel through time to whatever time you want to go to. Yeah, man, you know me. I've always wanted to see the dinosaurs. So, catch you later. Oh, it worked!
Mommy, are we almost home? We're almost there, sweetie. But Mommy, I want to drink now. Are you thirsty? I'm so thirsty. I'd even drink a Pepsi. Stop that! Pepsi just doesn't grow on trees. But Mom. But Coke does.
Got my Coke. Stop!
What's in the bag?
What bag, officer?
You guys are gonna go away a long time for this.
Friends, the point which I wanted to, to which I wanted to draw your attention through this, that is again a different area which requires hours together discussion on what is comparative advertisement and when it amounts to disparagement, etc. The difference between puffery and disparagement also is to be understood through various developments in different jurisdictions. But let me just summarize the whole development here. The law related to comparative advertisement disparagement runs on these principles. Number one, I, as the proprietor of a particular product under a particular trademark, I have every right to say that my goods are the best in the world. That's puffery, right? Even if it is not true. Second one, I also have a right to say that my goods are better than any other goods in the world, even if it's not true. That's again another extent of puffery. I'll be able to compare my product with other products to say that my goods are better than other goods. However, the last principle is, I do not have any right to say that the goods of others are bad or worse. The moment I, in the course of comparative advertisement, either directly or indirectly say that the goods of others are bad or worse, that amounts to disparagement. If it amounts to disparagement, it is against honest commercial practices. If the advertisement is made of another trademark, which is contrary to the honest commercial practices, it amounts to trademark infringement under section 29, subsection 8 of the Trademarks Act. Even without using the trademark, if you make a comparison and leads to disparagement, it is a case for civil action under the common law principles, right? So that is the thing about comparative advertisements. Well, friends, with that background, let me just move to the last segment of my presentation. Although I know there are many other things that are to be discussed, which are all here very much on my slides, but still, let me just go to one particular aspect, that is how, because I'm conscious of the time, how the trademark principles are applied in the internet context, right? And if time permits, I'll take you through the common law remedy of passing off, if required. Otherwise, domain name dispute resolution issues how do you connect trademark and domain name? And before that, what is this domain name that we have been talking of? It's an URL, Universal Resource Locator. Right, HTTP here indicates the Hypertext Transfer Protocol. And I'm using the word NLS here. NLS.ac.in constitutes the domain name. And you know, there are two types of domain names. One is the top level domain name, like .com, .edu, so on and so forth. And then geographical top level domain names in the form of .in, .fr, .au, etc., etc. Well, then, if you want to look at the structure of the domain name and locate where NLS is, .in refers top level domain name. It's a geographical top level domain name. Then AC refers to the second level domain name, and NLS, which is the key here, refers to third level domain name, and www, of course, is a fourth one. Then if you want to look at it from the internet context, the whole thing, the entire internet is there, and within that broader internet, you have the country top level domain names. I have indicated .in. There could be similar one also, and within that, you find again the first level domain name in the form of .ac, .rec, .co, .gov, etc., etc. And ours is AC. Within that particular AC, right, I'm taking you to the NLS. Like NLS, you have other institutions also, IAC, etc., etc. And then within that, you have the server located, right? From here, it moves on. And you have the name www.nls.ac.in. From that, we are going to access to the internet. This is the domain name that we have. And what are the problems? The hierarchical structure, if you look at, you find the root is there, and the top level domains in the form of in and .com are there. And then comes the second level domain name in the form of AC, CO, etc., etc. And finally, from that, you come to the specific third level domain names. The problem is always with the third level domain name because that is likely to conflict with the trademark of some other person. Let me just give you and start with an example of what this Taupin, the defendant in this case, Dennis Taupin, did. Dennis Taupin, right, he is a notorious cyber squatter. You know who a cyber squatter is. He registers the domain name and would not allow any other person to register their entitled name as a domain name. He squats on the cyberspace. He's called a cyber squatter. So he was a notorious cyber squatter. And you will be surprised, he went and registered around 240 domain names in the domain name process started. And amongst them were all multinational corporation names, Panavision, Marks and Spencer, Cathay Pacific, all airlines, all multinational corporations he registered. And when they wanted to register, he said, I'm going to offer to sell it. And he said, you should pay me $13,000. So he went on demanding the premium for all these things. And Panavision here asserted that Taupin, right, intention was to extort money. It had, since it had owned the federal trademark registration. They sued them under Federal Trademark Dilution Act. And ultimately, the Ninth Circuit went ahead and said, the use of this particular domain name by Taupin and registration of that has diluted the Panavision's trademark, right? And it's in violation of Federal Trademark Dilution Act. It also says that involuntarily forcing a company to leave its registered trade name and reputation to the mercy of a cyber squatter constitutes dilution of the trade name. So this is one particular case, and series of cases have followed after that. And then card service is another which followed the case. And in UK, in Marks and Spencer was 1 in a million, where 1 in a million had registered similarly the name Marks and Spencer so that it can sell it to them. The court, I just read the last part of it. The court here grants injunctive relief, and it says that you are using the domain name, and the domain name here that you are using to defraud Marks and Spencer could be considered as an instrument of fraud. So you're using domain name as an instrument of fraud. And in India, we have this domain name under the ministry. Nixon is regulating that. And there are several registrars for administration of this particular domain names. The first case that came before the Delhi High Court, right, was Yahoo versus Akash Arora. Akash Arora here, right? They registered yahooindia.com, yahooindia.com, and then started using it. Yahoo Incorporated filed a suit against them for passing off. You know, they filed a suit against them for passing off because it was prior to the new legislation that came into existence, Trademarks Act. Trade and Mercantile Marks Act had not provided protection for the services. Yahoo is providing services, as you know. Google is providing services. So it's a service mark. And therefore, they went in for passing off action. Petitioner here contended that defendants had verbatim copied the format, contents, layout, color scheme, and the source code. And therefore, they are liable for passing off Yahoo. Though Yahoo, Akash Arora takes up the defense that it is not Yahoo, it is Yahoo India, separate. So disclaimer is there, but still the court goes ahead. The issues were these. Can there be protection for domain name in law of trademark? Whether registration of domain name in India is relevant consideration for purpose of protection. Whether protection, if possible, would have been in the statute or whether it should be in the passing of. These are the issues that came before the court. And the court decided like this, saying, domain name has same function as a trademark and is an instrumentality of goodwill. It can generate goodwill. And relief for passing off was allowed by the court, saying that since it's not protected under statute, passing off action is an appropriate action. And business reputation has been wrongly exploited by the respondents. And they need to ensure commercial stability. And also they said disclaimer does not absolve liability. Likelihood of deception is sufficient, and therefore relief was granted in this particular case. And after this series of cases have come before different courts, which are not required for our purpose, but ultimately the Supreme Court in Satyam Infobase versus CiFiNet Solutions, it validated the application of trademark law for preventing the use of deceptively similar trademark, right? Friends, this is a case where CiFiNet and then CiFiNet.com. And you see how the defendants take up a defense here. They say here CiFi is derived from our promoter's name, Salim, Ibrahim, Fazal, Fahid, and Yusuf. Right? It would have been some other name also, but they wanted to tag on and then say CiFi and CiFiNet. This indicated a malified intention on the part of the respondents. The entire set of passing off principles were applied, which again, I'm not going into those details of that at this particular stage. Maybe in the course of discussion, we may if required, but ultimately it said that this is likely to cause deception and misrepresentation is there. Hence, right, this amounts to a case of passing off. Remedies were given. Well, friends, let me just to conclude my debate. As far as domain names are concerned, there is also a remedy under the ICANN that's popularly called as Uniform Dispute Domain Name Dispute Resolution Policy. It is applicable to disputes where the complainant asserts these following: 3 essential elements. One where he says that it's identical or confusingly similar to the trademark or service mark. Second one, he says that the domain name holder has no rights or legitimate interest in respect of domain name. And the third one is domain name has been registered and is being used in bad faith. So these 3 aspects will have to be established. There's confusing similarity. The domain name holder does not have any legitimate interest. And finally, it was registered and used in bad faith. What would amount to registration and use in bad faith? There are 4 circumstances which have been mentioned and specified in the guidelines itself. Something like if it's primarily used for selling, reselling, or otherwise transferring domain name for to the complainant, etc., etc., or to prevent the trademark proprietor from using it, primarily for the purpose of disrupting the use by the competitor. These are considered to be registration in bad faith. If all these 3 are proved, then it would amount to violation of the rights of the trademark proprietor, and you can initiate action under the UDRP, and UDRP has very, very quick and fast remedy and timely fashion is going to be resolved. That's, friends, these are the ICANN approved UDRP providers, and there are many more now in the pipeline as well as functioning. It can be resolved. Let me just conclude on domain name itself with a very interesting anecdote. It's not an anecdote, it's a fact, a case that went before the Second Circuit of the New York in USA. You know, PETA.com. PETA, all of us know, PETA.org was the registered one. PETA, PETA means People for Ethical Treatment of Animals. People for Ethical Treatment of Animals. Right? And this PETA is also a registered trademark in quite a few countries. So someone in New York registered PETA.com and made a disclaimer in the website itself. It was PETA.com, and when people clicked on PETA.com and entered into the first page, that first page clearly indicated, we are not People for Ethical Treatment of Animals. We are a different organization. You have to click again. You clicked again, and the next page said, we are different, but we are PETA. What is the different PETA? They said, we are people eating tasty animals. We are people eating tasty animals, and therefore this is our PETA. Then if you just entered into the further pages, you would find the information about the non-vegetarian dishes that are available in different parts of the world. You can click on, and then go to different parts of the one. So now this particular question went before the court. And the defendant argued and said, this is a parody. It's a parody. PETA is there and we are just parodying that. Parody is a defense in trademark law as well as copyright law. Copyright law parody is very, very interesting development. I'll not be touching upon copyright and other things. It's a parody, they said. So what is a parody? I'm sure you must have understood by now what a parody is after having done a course on copyright law. I'll just give you a simple way of explaining this. You would have seen on MTV long back, a person with short man with a beard used to walk into the podium like Amitabh Bachchan and give an impression that it is Kaun Banega Crorepati. But when he came and started his questioning, right, he would again give an impression that this is question and answer session. But the question pattern and the look, etc., it was entirely different. Audience first get an impression that this is a program by MTV. This is, they are reminded of Amitabh Bachchan. They are also reminded of Kaun Banega Crorepati. That's the first message. And the second contradictory message is also sent simultaneously. Second contradictory message is, we are not Kaun Banega Crorepati. This is not Amitabh Bachchan. So if two contradictory messages are sent out simultaneously, the second word could be a parody. This is what the Circuit Court of New York said while deciding this case. Then, friends, is that all the parody here? In case of parody, you are just picking up the popular portion of the popular version just to remind people about the popular version. That's all. And beyond that, you have created your own work. If you have created your own work distinct from the popular work, then that would amount to a parody. And parody should be, right, in a very positive sense. Humorous association is permitted, whereas injurious association will not be permitted. Let me just draw the distinction between these two. Someone comes out with an advertisement. An advertisement says, if you just look at the advertisement, you are reminded of Coca-Cola's advertisement. You have seen enjoy Coca-Cola with all those drawings. And this person who comes out with this particular same background, he writes the word enjoy, and below instead of Coca-Cola, he writes cocaine. Enjoy cocaine. That's an injurious association. It is not a humorous association. Right? On the other hand, you have heard about the doesn't know Barbie. right? Barbie is a trademark. The Barbie moved from France to US and has become a household of US. Barbie, MCA company, another recording company, it comes out with an audio, with a music album. I'm sure most of you would have heard about this. I'm not a good singer, but still, to make you remind of that particular song, this is how it runs. I'm a Barbie girl, right? You must have heard about this. I'm a Barbie girl, and that continues. Barbie, Barbie.
Participants, sir is not in the meeting right now due to network connection. I think he's disconnected. So kindly hold on patience. I'm connecting with Ramakrishna sir. Hold on patience, please. Sir. Yeah. Okay, sir. Participants, sir is connecting again. Please hold patience. Do we have Diganto Biswa sir in the meeting? Sir, I would like to see you if you are there in the meeting. Sir, I request you. Diganta Biswa sir. I saw him joining. Mohan Rao sir, did you give the link to Diganta Biswa sir?
And I too saw at the beginning, and now.
Yeah, he's not there now anymore. I have invited him to the program,
Okay.
but I don't know if.
You call and ask now. He would like to join again.
Yeah, I think he got disconnected too. Let me call Diganto Biswa sir.
Yeah, right. And Harish sir, namaste. And as contemplated, we had a fabulous academic feast.
Yeah.
And with the threadbare case analysis and a very great comprehensive session we had with Ramakrishna sir. And, yeah. And Harish sir, unmute yourself.
Yeah, I was listening to him. I was not on the video. I was.
Yeah, that I understood. And you must have been attending too many tasks.
Yeah. No, I have two systems. Sometimes two webinars happening, so I keep swapping in between also at times.
And we missed many, and it's worth missing.
Huh?
We missed many, but it's worth missing and for this.
No, I was listening. I have put a headphone to me and listening to another one on other side, listening to the headphone on one side.
You are like NTR who can act, sir.
Sir, today you have to do multitasking, sir. What to do?
That's what you are very great.
See, I have one more here in front of me. Another laptop in front of me on which I was on another webinar.
Ramakrishna sir is there now, and even Mohan Krishna salutations. Mohan Krishna is also an expert who should have been a panelist here. Yes.
Ramakrishna sir is
Welcome back,
Prasenjit,
Ramakrishna
make
sir.
co-host. Prasenjit, make sir co-host.
Ramakrishna sir?
Yeah, I admitted him, and you need to make him co-host.
Okay, I called Diganto Biswas sir.
What is
He
he
will
saying?
rejoin. He will rejoin. He said.
Good. Good to see a lot of good friends, including Mohan Krishna sir, a fabulous presenter. He is also on patent law, his pet subject.
Then till Ramakrishna joins, I think Mr. Mohan Krishna sir should.
Ramakrishna sir joined, but he is unable to.
No, till such time, I think Mr. Mohan Krishna should fill in with some.
He can. And unmute yourself, Mohan Krishna sir.
Mohan Krishna sir has to unmute.
Sir Ramakrishna sir, but the only thing is I can request him to fill certain gaps which has missed, particularly because the paucity of time. And I thought
that's okay.
I'm asking him to enlighten on prior user rights, because the prior user rights are going to have
Yes, sir.
it has its own importance.
On this earlier, on this prior user right, which is a very important right. Even without a trademark registration, you can still enforce your right and retain your trademark with a prior user right. Whirlpool case is a historic case on hand in that matter also. And even Vistara.
Professor is back.
Ramakrishna sir is back.
Ramakrishna sir is curiously looking at Harish sir, a good friend, lamenting on something. Welcome back, sir. Welcome back. You please unmute yourself. Kindly unmute yourself, sir.
No, sir, Mohan Rao sir, please. I think he's having some network issue. That's why. Otherwise, he would have. Let's give him some time, sir.
No, he is there. He is there, available. But he should just unmute himself.
Oh, yeah, Prasenjit, make co-host to Ramakrishna sir. He's not able to talk.
I made him co-host.
He's to unmute. Please tell him over the phone.
No, actually he got disconnected again, I think so.
Acha.
Ramakrishna sir, are you hearing
No,
me?
he is visible. He is visible.
You will have to unmute.
Yes.
Sir, are you hearing me?
Yeah.
Yes, did it.
Now it's done. You have done it.
Now, sir,
okay, sir. Okay, sir.
Yeah, Prasenjit had prevented.
Please go ahead, sir.
Oh, Prasenjit, why did you prohibit sir from joining?
Sorry, sir. Sorry, I apologize for it, sir.
Over anxiety, over anxious in organizing things.
Right.
That's fine. Please go ahead, sir.
I was just concluding there. There are many other issues that we can take up, but just to conclude on this particular thing, the second circuit said, there is something called as initial interest confusion. What is that initial interest confusion? A person looks at www.peta.org and www.peta.com, and at the stage of clicking in on that particular URL, is there a confusion? yes, PETA and PETA are confusingly similar. And he gets into that particular web page and then realizes that this is either for him and then continues there if he's a person eating tasty animals, or if he wanted PETA, he would come back and then go to another PETA. So there's a confusion. That initial interest confusion is a confusion. And therefore, that domain name PETA.com cannot coexist with PETA.org. It's confusingly similar. And then that was removed. And now you can't search for people eating tasty animals under that particular name at all. It's in a different name. That is just to highlight the fact that it is a parody. Parody could be a defense, both in case of copyright as well as in case of trademark. And as far as copyright is concerned, the popular case, Campbell case, is there in US, and there are a series of other cases that came subsequently. Well, let me just stop at this particular stage and take up any questions and any debate that I can respond to. And I find Mr. Mohan. Yeah, Mohan, go ahead. Yes, sir, Mohanji. Oh, not Mohan, I think. Harish is there. Yeah.
Harish here, sir.
Harish.
Sir,
I
congratulations.
overheard some about Whirlpool and other.
Yeah. This is, I mean,
that particular part I have skipped here. As far as passing off is concerned, I skipped because of lack of time. Yeah, please go ahead.
I think passing off is an important thing because a lot of people don't understand what is a passing off. So I think a little, if you can throw light on that with reference to Whirlpool case, Vistara case, or anything like. The other one is I wanted you. It would be beneficial to other participants. I'm an advocate practicing in Bangalore.
Good.
I was at the NLS in 1990 batch for LLM, and it was still in Central College before I quit and started practicing.
Correct.
This is I wanted you to throw some light on rectifications, amendments, and cancellation of trademarks already registered.
Yeah. It's not working. What happened?
You might show the replica of your granddaughter and explain.
First day she was there. Yeah, you are right. First day she was there.
Yeah.
Somehow it's not going back. Oh God. I'm trying to share that particular thing. Yeah. I'm sorry, just give me a minute. Yeah, but anyhow, I can just start my debate on this. See, as far as passing off actions are concerned, which Mr. Harish rightly referred to, passing off actions, there are two. One is the classical form of passing off, the other one is the extended form of passing off. But as far as classical form of passing off is concerned, it is applicable when there is goodwill associated with a particular product and a particular representation of the goodwill, right? And the three elements that you find here, they are number one, there must be reputation or goodwill associated with the product, and number two, there must be misrepresentation or deception caused by the respondent, and the third one, there must be damage that occurs. That if these three are established, then that would amount to a passing off action. But passing off action has had its wider ramifications. right? Much beyond just a particular product. When I say extended form of passing off, this is the test laid down by Lord Diplock in Erwan warning case. Erwan warning case is a case where the goods were in the form of what I say geographical source, right? It was popularly called as avocat. Literally, it's called as advocat, right? But it's pronounced as avocat, A-D-O-C-A-A-T, avocat. And Erwan Warnick was selling avocat. When he was selling avocat, there were several other producers who were selling avocat. And the respondent also started, Townend also started selling avocat. The difference between the first one and the second one was, the second one they used Cyprus sherry and not the spirit. As a consequence of which the product could be sold at a lesser price. And Erwan Warnick sued them. And the defense that defendant took up here was, well, avocat is a descriptive term. How can you claim trademark protection for that? But prior to that, there were a series of other cases decided. Lord Diplock accepted the finding of facts of the lower court. The lower court had clearly said that this is a distinctive mark and not a descriptive mark. Although this name refers to specific components of a particular product, still it has acquired such a wide reputation in the market that this has become a distinctive mark. That's the first one was settled. Second one, how do you determine passing off? The Lord Diplock says that there must be trading by a trader, and in the course of trading there must be misrepresentation, and the misrepresentation must be calculated to cause injury to the consumers or the other party.
The other side.
Yeah, and then that is those four pronged tests were laid down by Lord Diplock, and the 5-pronged test here is called as an extended form of passing off. What do you look at in case of extended form of passing off? There would be not an individual goodwill, but a collective goodwill of many persons. And the second one, any of these persons who has a goodwill will be able to file a suit for passing off. And then the damage part remains. The damage part, both in case of classical form as well as here, would remain. That will have to be established. Now, the three elements, if I can look at the three elements as such, the goodwill element or the reputation element has a lot of legal complications, right, within the framework of passing off. What is that complication that arose or arises in that particular case? Goodwill, right? Goodwill and the trade. Should there be trade in order to create a goodwill? Or can there be goodwill without trade also? These are all the questions that have come up over a period of time. And in passing off, the courts have applied something called as soft lane approach and the hard lane approach. And you will be surprised, UK even now is following a hard lane approach. Supreme Court decided just 4 years back that we continue to hold the hard lane approach as the approach for deciding passing off. It was a case, right, it was a case relating to a TV service provider from Hong Kong, and they did not have a presence in UK. The Supreme Court says that not having presence in UK is as much as not trading in UK. If it's not trading in UK, the trans-border reputation itself would not entitle you to any remedy, and therefore you can't claim this. So what is the soft lane approach and hard lane approach? Let me just point out that. In case of soft lane approach, the trans-border reputation is taken into consideration while deciding the passing of action. And India, luckily, is following the soft lane approach. That is where Harish and others were referring to all the case laws, right? The series of case laws starting from Harper Brothers, Whirlpool, Vistara, whatnot. All those cases, including Microsoft cases, they are all Calvin Klein case was the first case. Calvin Klein, all these cases are relating to soft lane approach only.
Even
Calvin
Cadillac. Cadillac also.
Cadillac also, yeah. Caterpillar also, the same thing. In all those cases, there was trans-border reputation, but none of them had registered their trademark in India. International apparel from Calcutta started using the word CK, and the court said there is trans-border reputation and people know about this particular word, and therefore that reputation needs to be protected, And if anyone wants to pass off the goods under that name, is liable for passing off action. So that is what is called a soft lane approach. Whereas in case of hard lane approach, they said, well, there is need for trading activities to be going on in that particular jurisdiction for that to acquire reputation or goodwill. And in the absence of that, it doesn't take. I distinctly remember Lord McNaughton, right, in one of the cases, in river remedy case, something like that. In that case, he makes a categorical statement saying that business is associated with goodwill. Take away the business, goodwill vanishes. It goes. And there are a series of other cases which come up now. Supposing I have not started trading at all. Tata company has started its activities, releasing several products. And imagine tomorrow it wants to release another new brand new product into the market. It starts advertising, but it has not produced that particular car at all. The car has not come into the market. And now tomorrow, if some other person wants to use that particular name, assuming again that Tata has not gone for registration of trademark in the trademark registry, assuming that if it has gone for registration,
nano car issue was there.
That happened there, yeah, nano car issue happened. Exactly. And now, if some other person wants to use a similar name, and if what Tata wants to prevent that, how would it prevent that? Since the product is not there, there is no trading. Since there is no trading, there is no trader for that particular product. In the absence of trader for that particular trade, where is the goodwill generated here? So this raises a question whether there is what is called as pre-trade goodwill or not. But the courts have gone ahead and said, especially in BBC case in UK, the courts have gone ahead and said that well, if there is an established reputation for the organization as such, for the Tata company in this case, then that reputation could pass on, exactly. That reputation could pass on to the new products, a new name that is going to release, and thereby there could exist a pre-trade goodwill also. The next question that comes up is, yes, you stop your business once for all, wind up your business, Tata company closes, and then some other person wants to use the word Tata. Because there's no Tata now, right? Is there goodwill existing after the trade ends? It's also a question that has come up here. I'm only talking about the goodwill part now.
Correct.
Goodwill part, right? Whether there is also goodwill there or not. And one of the cases the Privy Council has said, Star International case, Privy Council has said that if the organization has wound up, but if it is existing in terms of reputation, then it will still have the opportunity of gathering up the prevailing reputation and then gaining the goodwill, and it will be having a locus standi for filing a suit for passing of action. So post trade goodwill is also possible. But
Whirlpool case happened like that only. Whirlpool in India had closed down, but it had a worldwide reputation.
Worldwide reputation. Similarly, Tiger Bomb also. Correct. Tiger Bomb case, the Harper brothers were from Burma. They were from Burma, and they were trading in India. And because of some import restrictions, they could not sell the Tiger Bomb in India. Meanwhile, a person from Tamil Nadu started using the word Tiger Bomb.
Yes.
Right. And then it became the problem. And of course, the court said that, well, even if they're not trading here, that by mere misuse, non-use of that, it would not get automatically, right, deregistered. It would not get that particular status. Still, the reputation continues, and therefore, you will have the remedy against a person who is going to infringe upon that. And again, you find non-use section 47 of the Act. That is what perhaps Mr. Harish is also referring to. 45, 47, and 48, these provisions he is referring to.
Very true.
Well, yeah, well, I could make out. Immediately, the moment you raise the question, I could make. 47 is a case where you are trying to remove the trademark from the registration for non-use of the mark. For non-use of the mark. What is non-use? Again, my God, that is, I think any law student should take up this particular thing and start looking at the research on the word use itself. Whether the use should be commercial use, and what is the kind of use. Supposing I, as a promoter of a particular company, get registered a particular name, and I do not use it. The whole intention of mine is to transfer it to the company which I am going to establish. Initially, I have registered it. So in that particular case, can you say that registration was done without any intention to use it for himself? And therefore, could it be cancelled? because Section 18 of the Trademark Act clearly says that either the person who is already a proprietor of trademark can go for application for registration, or a person who wants to be a bona fide user of that particular mark for a particular goods also can go for registration. In this case, am I a bona fide user, or is there non-use of the product? In such circumstances, there is an exception provided in Section 47 itself, which says, yes, you can take up as a defense the extraordinary circumstances under which you are unable to use it for any purpose in India. One circumstance is war situation. Another circumstance is import restriction situation, right? And these are circumstances where you can still defend and then say the non-use was for a valid reason, and therefore this should not be rectified. It should not be removed from the register, right, sir?
The last one is, sir, wrongly registered trademark continuing to remain wrongly in the trademark register. What action?
Yeah, I think you should tell me as a practitioner what are you going to do.
No, this is a
Safest way,
point.
Yeah.
This is a very interesting point, so I thought it's better that
yeah,
your views on this also.
Please initiate. I'll comment on that.
No, that's what a wrongly registered trademark continuing to remain on the trademark register. Who is going to take action against it? As long as people are aware of such a thing. How to identify that?
Yeah,
that's the biggest challenge under the Trademark Act at the moment in India.
Yeah,
the competitors are expected to do that, because when once it is put in the domain and in the freezing period, that is what is happening, and the competitors, if any, they would move the.
To identify which is a wrongly registered trademark is $1 million question.
Yeah, that's correct. That's correct.
This is the greatest challenge under the trademark law at the moment in India. Lot of names wrongly registered continue to remain, and no action against it. Mohan Krishna sir, your views, if Mohan Krishna sir has something to say, all that also. Interesting point, that's all.
With regard to the distinctiveness is concerned, there is a provision the trademark law professor can enlighten us. And during the at the time of registration doesn't have distinctiveness, at least up to the challenge period, if because of its use at obtain the distinctiveness, again it can be upheld. And they don't look into this absence of distinctiveness at the time of making application. I think I'm subject to the correction by Professor Ramakrishna.
No. The provision is very clear. There's a provision which says, as far as distinctiveness is concerned, that cannot be questioned after a certain stage. There's a time limit for that, and after that, you are not going to question the distinctiveness of that particular mark, and that remains there. But the question of Mr. Harish is that which remains there is deemed to be distinctive, right? It's deemed to be distinctive. There's no doubt about that under the law. But can you remove that?
That's the
who should take action?
That's the question.
Mohan was trying to say that someone who is interested should take initiative. But then the next question is whether it is wrongly remaining on the register or not is again a big question.
Yeah, that's the one.
Yeah, can you just go in as US went once for removing all the dead woods?
Like how you are repealing all the unused acts. Some proactive action from the registry itself should happen also.
It happened from the registry.
Monitoring registered trademarks is not happening, whether they are being in use, not used, was wrongly registered. Proactiveness from the trademark registry is not happening.
Yeah, no. When you say wrongly registered, there are multiple questions or a host of questions that come here. What do you mean by wrongly registered? Right? Did the trademark office ignore Section 9 and Section 11 while registering this particular thing? Did the trademark office ignore Section 13 and then other provisions while registering this? For example, names of living persons.
Correct.
Abdul Kalam's name has been registered. And can Abdul Kalam's name be registered? He was the president. It has been registered. Who registered? That is the next question. They will have to get into that particular part. They'll be surprised the close relative of Abdul Kalam has registered that. Right? If it's by third persons, perhaps the trademark registry would have refused. But since it is from the closest relative, they have permitted them to register the particular
family member.
Mark. So like that, are there marks which are registered in violation of the provision itself? Again, you find in all the legislations, Mr. Harish would agree, not only trademark law, but all legislations have good faith provisions.
Yeah, and
if
fair
the
use.
Trademark registry register that in good faith, you will not be able to take action against the trademark officers at all.
Correct.
something like Patent Act also says that if the patent is granted in good faith by the patent office, you are not going to question the patent office, but you're going to question the patent itself. Question the patent in the court of law, and then try to revoke that particular patent, but not going to question the trademark proprietor and the patent examiner who granted that. So this good faith provision is there everywhere. But this requires an administrative action at this particular
That's what I'm looking at.
removal. And an incident happened here. There is a precedent for that. US, long back, some 20 years back, it started weeding out, it's called as the deadwoods. Started weeding out all the deadwoods, saying that there are many which are remaining on the register without being used. So for non-use, it can be removed. And one instance, if I can recall, even Infosys, the word Infosys for a specific product of Infosys was revoked for non-use after 5 years. Infosys as a trademark for the entire services is remaining, but for a specific goods, it was removed. There's a trademark registry. That's possible.
Thank you.
Yeah.
That's good. And the question
Thank you so much.
answer session may continue, maybe taken up and continue. Prasenjit.
Yes, Mohanji.
Prasenjit.
Sir, please rather enlighten us with regard to the prior use, sir, prior user rights.
Wonderful. Sir, that prior user right, again, like the one which
Whirlpool.
is again a very vast. No, Whirlpool is one. I think you should go to the latest decision given by the Madras High Court in Krishna Sweets case.
Krishna Sweets.
Yeah. And prior to that, the Jarda, what was the Jarda?
Panparag.
No, sir. The name of, I'm not getting the, yeah.
Kenny something?
No.
Name of a person? Name of a person? I'm sorry. I'll let you know. This is what happened. That very popular, it's a very popular Jarda manufacturing thing, and it was manufactured and selling, and it taking advantage of its position, it sued a small manufacturer in one of the places in Lucknow or somewhere. And that goes before the court. You'll be surprised. The court says that in this particular case, the respondent, a small manufacturer, was the prior user of this particular thing, and he continues to have a dominance, and you can't move against him. And then there was a counter claim for cancellation of registration of this, and the court acknowledged that and then canceled the registration of a popular brand, and that is now using it some other some other name, and it's for marketing its particular product. So the name of an individual, right, which is confusingly similar to the prior user, right? So prior user has these rights. Prior user cannot be proceeded against by the trademark registered trademark proprietor, even if it's a registered trademark proprietor, right? Can the prior user seek registration now? I'm not talking about the registered user. The registered user, then he can definitely get it corrected and then remove that from the register on the ground of deceptive similarity. But a prior user who has not registered that, what are the remedies for him?
He can register, sir.
Yeah,
he can register.
I'm coming to that. He has not registered now. Under what ground can he register? So the problem now which comes up before him is he will have to inevitably invoke Section 12 of the Trademark Act. Section 12 of the Trademark Act provides for honest concurrent user.
Correct.
And then when he goes for honest concurrent user registration, the registrar can impose certain conditions and then grant the registration. What would be the condition? Usually the condition would be geographical limitations, disclaimers. You can use this, but you say this particular disclaimer so that the consumer will not be ultimately confused. But registration, yes, registration is possible. But again, the problem is there is need for concurrence. This is the practice part of it. Mr. Harish would be knowing that. You need the concurrence of the prior registered proprietor for honest concurrent use registration. See, that's the problem to which the prior user would be put. But as far as legal indemnity is concerned, he is indemnified from being sued by the registered proprietor. He can continue to use that particular thing as long as there's a disclaimer and then as long as there is no confusing similarity. Section 30 onwards, 30, 31, 32, 33. Right, those are the provisions which highlight the rights of the prior user. Anything else you want to add?
No. Yeah. I call upon
to
look into the other questions and continue
Yeah.
the question and answer session.
Please, please.
Anyway, sir, as far as passing off is concerned, there has been incidental references. Even regional variation has been taken into consideration in TV Venugopal case.
Yeah. That
Throw
Ushodaya case.
more light on that.
Ushodaya case.
Yeah, Ushodaya.
You have referred to that particular case already.
That's what. Anyway, I was of the opinion that it has been wrongly decided. Because they belong to two different fields.
Yeah.
And therefore, TV Venugopal must have been given the benefit. That hasn't been done, and the so-called goodwill and other things have been taken into consideration. And the hardliner approach, which must have been adopted by the Supreme Court, hasn't been adopted. That's what I wanted you to throw light on that.
Sir, here the hardline approach would not come into
more of a subjective satisfaction of the judge.
For the simple reason.
That's where I differ with
the hardline and softline approach is not here because it's not a question of repetition. Yeah. Yeah.
In most of these cases,
there are quite a few. And
in most of these cases, subjective satisfaction of the judges is what is happening in the court.
Because
the line of argument also was quite interesting. And when Inadu incense sticks were registered in Karnataka, the name that signifies Inadu, the meaning of the name also was taken into consideration. Inadu in Kannada means this land. Whereas Inadu in Andhra or Telugu language, it means today. And that distinction also, having all these disparities also in mind, there hasn't been the benefit given to TV Venugopal, and that was quite surprising. And the way the court had taken into consideration all the precedents
approach
elaborately from various decisions, yet ultimately TV Venugopal was put to loss.
Sir, interestingly, the session judge trial court has gave an order on passing off. Standing on that, the other people, Bangalore people, preferred an appeal before single judge bench, and where the single judge has set aside the lower court order. And again, these people preferred an appeal before the letter patents appeal. The letter patents appeal, again, they were successful on the ground of copyright and trademark, who the Ramoji Rao. And Venugopal preferred an appeal to the Supreme Court over that. And finally, it has given the Ramoji Rao a new rather benefit or prize, like it is a well-known. The Supreme Court said it is a well-known mark in the Telugu-speaking states are concerned.
Yeah, that's what.
Correct.
I don't know, when there are two different distinct fields and usage of name, how can you attribute to a particular prior user or something like that? And okay, as far as the design is concerned, if you have objections, that can be just prevented. But as far as the name is concerned, you must have asked him to continue your business in your own area. But giving a particular time limit of exhaustion of the goods, till the exhaustion of the goods, you can market and you need to close down. And he is nowhere in the picture. And now TV Venugopal, I think our Harish sir,
I know him.
Presenting.
I know him. He's
nowhere in the field.
More of real estate.
Doomed to the logical end because of the court decision. Because he was almost closing down his
Ashiki Agarbatti.
Ashiki also was there. Inadu, Ashiki, all those things. It has been closed down.
Yeah, but what happened to, I think Harish was practicing in Bangalore, knows what happened to Mallappa and Company.
Correct.
Right, Mallappa was engineering
company.
products, nowhere related to food. He started using, Mallappa and Company started using the word M, McDonald's M.
Yes.
Correct.
And if you apply the same logic, the court should have not have applied. Court should have permitted him to continue with Mallappa and Sons, M.
Correct.
M had become an internationally renowned, reputed mark.
Sanitary
So
ware, they are
therefore
very popular.
Exactly. The well-known mark concept has crept in, perhaps, Mohanji.
Yes, sir.
Even in case of Ushodaya case,
Yes.
the well-known trademark concept must have crept in, and that must have influenced the judge deciding this particular case.
That's correct. And
Looks
they,
like.
in a way, what I feel is that they are biased towards Ramoji.
No.
They had
Right.
taken reasons from the other way around possibility.
All celebrity status people,
See,
somewhere some inclination will be there towards that. I think
what happens in this entire
there
process
here.
is, so what happens in this entire process, I just want your quick remark. Once this well-known trademark concept comes in, and you start refusing registration of similar mark for dissimilar goods as well, then the whole classification of goods and services ultimately would get diluted.
That's good. That's what is happening, sir.
Right.
That's
the very objective of classification was to ensure that
you
we get protection only in a particular class of goods for a particular class of goods.
Yes, and if
that
you are
goes
not in
for a
this
toss
field,
now,
why
for a
should
period
there
of
be
time.
any objection?
More so when it is not similar trade.
Yeah, that's it. That's what. Okay, Prasenjit, please continue.
Yes, sir. Okay.
Yeah, continue.
SRK
Sir,
question.
there is a question.
On SRK.
Yes. Sir, what is your opinion on registration of names like SRK, STT, and Khilari by Shahrukh Khan, Sachin Tendulkar, and Akshay Kumar?
What is the problem? No, what is the problem?
Ramakrishna, sir, shall I continue or shall I repeat it?
Yeah, I got it. I got your question.
Okay, sir.
What is your question? You are registering a particular acronym of your name as a trademark. Do you know the word Gabbar Singh has been registered as a trademark? And
Yes.
many of the characters in Sholay have been registered as a trademark? And Harry Potter has been registered as a trademark? The case went before the Mumbai High Court when Harry Potter, the Warner Brothers sued them. I think it was 20th Century Fox. When they sued them, and in the court, the question was, is it trademark protection? Is it copyright protection? Copyright protection cannot be given for the titles. There are a series of cases,
correct,
right, including the Supreme Court decision, where copyright is not given for the title. Then they said trademark, fine. Harry Potter, and the respondent had used the word Hari Puttar for his movie. So now the question is there confusing similarity between Harry Potter and Hari Puttar? So the court took into consideration the audience in India, people in India. And the court comes to the conclusion, categorical conclusion, that no Indian will ever relate Hari Puttar to any Potter or Harry Potter. Yes. So there's no question of likelihood of confusion. So all these terms are registered. And Justice Manmohan Singh, latest, when Ram Kumar Verma's Aag movie, that issue came up, then he started using characters which are similar to Gabbar Singh and all those characters, Thakur and etc. And CP Association, they had already registered these as trademarks. Manmohan Singh categorically says that these are confusingly similar to already registered trademark, right? On the one hand, and therefore you can't violate the trademark of the plaintiff, the petitioner. And second one, it also goes ahead and says the characters in the entire movie, Sholay, has been, by changing certain nomenclatures, have been used here continuously, and therefore even the copyright violation happens. So trademark registration can be done for this, provided you are going to indicate as to the class of goods for which you're going to apply those things. If signature of Sachin Tendulkar can be used for a particular product, that what prevents the name of Amitabh Bachchan or any other person to be used for a product? That all that is required is Amitabh Bachchan should give consent for that. Right?
Yes.
Yeah, that's true.
Obviously, Amitabh Bachchan can't give any consent now.
It may not be out of place. Gabbar Singh, iconic character Amjad Khan, who portrayed that. Amjad Khan is the first villain in the film industry of Bollywood to have an opportunity to do a commercial ad.
Yeah,
of
yeah,
Gabbar Ki Asli Pasand, quality biscuit or something.
yeah. True. You're right.
Otherwise, only heroes were being given the commercial
Yes,
ad and endorsements.
He became so popular a woman that villain that every household, every child was even threatened to take milk and food.
That's
Correct.
By
that,
using
that dialogue is also there in the movie. जब बच्चा रोता है.
that's
Correct. True.
Okay, sir.
the same.
Shall I move on to the next question, sir?
Yeah,
Yes,
next.
please.
I do mimicry of Amjad Khan. I have done mimicry of Amjad Khan's Gabbar Singh thing.
You're going to do it now.
No, now don't.
In the valedictory session.
Please give a jhalak, no problem.
Okay. Sir, the question is that it is from Dr. Mohan Krishnan. Please
Mohan
explain
Krishnan
the
is
concept of.
Go ahead.
Yes, ask the question.
Yes, sir. Please explain the concept of dissimilarities in the essential features test.
As already explained in the.
Yeah. See, this dissimilarity issue, that's where I was referring to Cadillac case. Diachem case had focused on dissimilarities for the purpose of determining deceptive similarity. And that's a wrong trend, wrong way of analyzing deceptive similarity. And deceptive similarity test was laid down by Cadillac court by saying that you should look at the similarities between the two marks. And by looking at the similarities, you should look at the dominant features of the two marks. Put them side by side, compare them both visual similarities, phonetic similarities, as well as conceptual or overall similarities, or structural similarities. And after that, determine whether there's a confusing similarity or not. And therefore, similarity constitutes the most important part. Diachem case, if you go Diachem case, you will get a lot of interpretation on dissimilarities. But that is not the foundation for determining infringement or passing off action. Should not be. That is a wrong judgment by the Supreme Court.
Major difference between Copyright Act and Trademark case. Here we look at deceptive similarities. There we look at differences.
Now there we look at substantial similarities again. Not even the differences. No, substantial similarity. If it's substantially similar, we determine copyright infringement. Whereas here we are looking at deceptive
Similarity.
There also we look at similarities only. Again, if copyright, if you go for differences, then that will lead to different consequences.
That's the other reason why I said.
Yeah. You see, there is something called as intelligent copying. The Madras High Court in series of decisions in copyright have said about intelligent copying. Right. A person who copies invariably will have to be intelligent, right? And when he copies everything except few things that he is going to modify. And the extent of modification by him becomes relevant here. If they are, in spite of the modification, if the entire work looks substantially similar, it should amount to infringement of copyright. So that's the infringement of copyright. So substantial similarity. And if you go to copyright law, I'm sure most of you must have heard of subconscious copying. Yeah. See, I have heard a particular song today, and maybe after 10 years, I might not be listening to that. And now I start sitting and then start composing a music tone. I compose a music tone, and ultimately when I release it, intentionally I have not copied anything. But if the work is similar to the work which you already created, then the court will ask, right, did you copy it? I may argue and provide evidence saying that I did not deliberately copy. But the first question there is, was there access to that particular copyrighted work? Answer is yes. Is it substantially similar to the work? Answer is yes. Then you cannot take up a defense that your memory played a trick, right? and therefore it becomes subconscious copying of the work. So that is how copyright law applies.
Shall I proceed?
Yes, sir, please.
Okay. Sir, Dr. Mosumi Kolita is asking, what is the difference between trademark and registered symbol?
What do you mean by? I'm not getting here.
Yes, the question is not actually.
No. What I could guess from that is, see, now you use the word, right, Zadila, top you use the word TM. Or Zadila, top you use the word R in circle, right? Whenever a trademark is not registered, the word TM is used. You have just filed an application or you're using it as a trademark, you just use the word TM. But after registration, it is mandatory for you to use the word R in a circle, saying that that is registered trademark. That may be the difference between TM and R in circle. Yeah.
Okay, sir. Next question from Dulumani Bashya. What's the difference between collective mark and well-known trademark?
Yeah.
And trade name and trademark.
Yeah, it's not much of difficulty here. Well-known mark is for an individual mark which acquires reputation in the society, and there are at least 8 or 9 factors that are considered, which are provided in section 11.5 up to section 11.11. Subsection 11.11. They have provided various grounds on which the court or the trademark office can come to the conclusion that it's a well-known mark. For example, the promotion, the number of consumers, the geographical area, and then how they have tried to defend themselves against the unscrupulous user, all these factors. But registration is not mandatory for becoming a well-known mark. This is one part of it. Whereas a collective mark is a mark which can be used by the members of that particular organization, right? As part of that particular organization. That's a collective mark. And the second one, what is the second one that you said? Difference between?
Trade name and trademark, sir.
Trade name and a trademark, yeah. See, trade name, I gave that a particular example in the course of my presentation. Ellora Industries. Ellora Industries is trading it under Ellora Industries name itself. Right? Whereas for a particular product, they're using the word different name. So the name that is used with respect to the product as such, or the service as such, would become a trademark, right? Whereas if your style is different, style is under Ellora Industries, that's the trade name. Can trade name become a trademark? Answer is yes. Can trade name over a period of time become trademark? Answer is yes. You have a trade name and you go and say, for all my product that I want to sell, I'm going to use the same name. Yeah.
The best example is, to give another example, MEME Restaurants Private Limited, or some that is the name of the parent company which runs the KFC. The brand name of the product is KFC, Kentucky Fried Chicken. Okay, but the company name is a different trade name. That is MEME Restaurants Limited or something. That's similar.
Even HLL also, Hindustan Liver Limited.
Then Coffee Day, Amalgamated Beans Private Limited is the name of the company. Coffee Day is the brand name.
That's the trade name is of the company as such.
Yeah.
That's a trading style also.
That's right.
So it's a connecting question from the same person, that whether Patanjali and Amul is a well-known trademark or a collective mark.
No. Amul is definitely now a well-known mark. I think the court has declared it to be a well-known mark, and nobody can use that particular mark as such. Patanjali, it's not a collective mark as such. Where is the question of collective mark coming up in case of Patanjali? It's Baba Ramdev and his company which is being manufacturing and using it exclusively. And if tomorrow my friends, all of them are permitted to use Patanjali under collective mark, perhaps that may get the status of collective mark. Until then, you'll have to wait whether it becomes collective mark or not. I don't think it has become a collective mark as of now.
Sir, shall I move on?
Yeah.
Okay. The question from Sir Rishabh Bora. In case of collective advertisement, even if there is no explicit mention of the products with which the product is compared, if the consumer at large can make out to which the product is actually being compared, will there be an infringement?
Yeah. See, it will not be infringement, but it will be disparagement. It will be disparagement. See, this is what happened in the very first case of MP Ramachandran case. This is Racket Coleman, where they did not indicate the name of the product or the brand name. They merely showed an advertisement in which the, what is that, blue. That blue flows from a particular bottle and the bottle shape. By looking at the bottle shape and the way it moves, and by looking at the price at which it was sold, 10 rupees, right? Both would indicate that this is relating to a product of a particular company. And there, the court would hold it as, what is that? The court would hold it as disparagement, right? So that disparagement it can be. But section 29(8), subsection 8, refers to use of the trademark. You should have used that particular trademark. If you have not used the trademark, then there's no question of trademark infringement as such. But there would be disparagement. Yeah.
So next question is whether domain name also comes under Copyright Act.
Domain name coming under
Copyright Act.
Yeah, see, this is that's what I was telling you now. In Krishik Lalla case, the Supreme Court has very clearly said that the title of a particular thing cannot become a copyrightable work. Title cannot become a copyrightable work. And if you go by that, what is this particular domain name as such? Domain name is the one which entitles outsiders to get the address of the person who is hosting that particular thing. So it is an IP address as such. It's an alphanumerical IP address. Alphanumerical IP address that leads someone to that particular website. Where is the question of that itself becoming a title and becoming a copyrightable work? If title cannot get copyright work, domain name by itself may not be a title for copyright work. However, are you looking at the domain name as such, or are you looking at the contents of the web page containing that particular domain name? Contents definitely are entitled for copyright protection. I think Mohan and others can comment if they have any.
Yes, sir. Yes, sir. That should be the way how things actual content must be protected, and that deserves protection. Yeah.
Exactly.
Sir,
And yes, similar logic will have to be applied. The logic that you apply for title and the copyright will have to be applied here also.
If the title of the book is used as a domain name, sir. Title of the book is used as a domain name.
Title of the book uses a domain name.
Domain name.
Yeah. And is that likely to mislead the consumers about that particular product itself?
That's correct.
Naturally.
Yeah. See, I told you the title could be protected in the form of trademark, but title may not get copyright protection.
Copyright protection.
As I told you, Harry Potter could become a trademark. Yeah. And if you recognize a particular title as leading to a particular product, inextricably associated with that particular product itself, then it's misleading if you are using the similar domain name as a trademark. Sorry, similar name as a domain name. Yeah.
Dell India is a domain name. Dell India,
exactly.
India, Dell.com, these are all domain names relating
domain
to the product with the word Dell again. Even Microsoft.
Exactly. Microsoft.com is a domain name.
Domain name.
Microsoft
relates to the company also.
Exactly.
Name of the company.
Precisely.
And its products also.
Yeah.
Its products are also with the same name.
It's a trade name, it's a trademark, and it's a domain name. All three. Yeah. Now, because that UDRP that I was referring to, it insists on one condition, that the domain name holder should have legitimate interest in that particular name. Tomorrow, if I start a website saying that Amitabh Bachchan fan followers.com, right? I'm a fan, definitely. But tomorrow, if I use that particular thing, is it misleading? See, there are instances where juliaroberts.com was picked away. I had used all of them on slide. juliaroberts.com was used. Julia Roberts was able to remove that from the cyberspace.
Pretty Woman.
Yeah, Pretty Woman.
Pretty Woman. And that's the movie in which she clicks.
Yeah, precisely. And yes, please go ahead, Prasanji.
Yes, sir. Yes. Sir, can there be two marks coexist?
That's what I told
you. Yeah,
section 12 is the one which I referred to just now. 12 permits honest concurrent use. Honest concurrent use. When does honest concurrent use come? The interpretation of the word honest, the interpretation of the word concurrent, both are to be done. Have they been used simultaneously by each other? Whether each other are aware of the use of the other and still they have not taken any action against the other, tolerating the use of that, acquiescing the use of that particular thing or not. In that particular context, if they are bona fide permitting the other one to use it simultaneously, they become honest concurrent users. And they can definitely invoke section 12 of the Trademark Act and both of them can get registration for that particular mark.
Subject to prior users' consent.
Precisely, subject to prior users' consent. That's precisely.
Next.
Question from Anamika Kalita. Whether a company can change its trademark few years later after registration?
You mean to say the trade name or the trademark? If you are referring to company law, I will say
She have asked about
the trademark. This is that what which I asked you, amendment to trademark.
Can they change that particular trademark, you mean to say?
So, whether a company can change its trademark few years later after registration? That's the question.
See, that becomes an entirely new trademark altogether. You're going for registration of a mark with few additions there. Right? There are provisions, right? Section 14, 15, and 16, if you look at. There is what is called a series marks, right? Series marks. If you have a composite mark, you can split them and then say that part of this I want to register separately. Part of this I want to register separately, and comprehensively I want to register one particular mark. So that particular provision is there. And similarly, you can also go ahead and then register the same mark for different products of which you're going to sell. And that is also possible within the framework of trademark law. And if you are modifying it, the modified version would become a new trademark. And the previous one you'll have to get cancelled if you do not want to continue with the previous one. Right? The modified one, if it is almost similar to the previous one that you had, only you will have the right of registration of the modified version, which is similar to the previous one, which is possible and permitted. Okay.
So of course, if a different product is released and a different trademark can be applied by a same company.
A fresh one.
Sure. If it's a different product, definitely they'll have to take a different trademark.
Yes.
Yeah, fresh trademark they'll have to take. Because you can't use the trademark that you have taken for X product on Y product, and still claim the trademark protection. You can't.
There is a question from Dr. Pranay Kumar Aditya. Sir, can there be a trademark even if unregistered with a disclaimer to avoid prosecution?
Can there be?
Can there be a trademark even if unregistered with a disclaimer to avoid prosecution?
I'm not getting the question. The first part I could understand. Can there be an unregistered trademark? Absolutely. That is where passing of action would come in. You will still be having a right over the unregistered trademark. Right? The disclaimer part I did not write.
So, Pranay sir, if you can make it more clear, then it will be very helpful for us.
A disclaimer is only to avoid prosecution. That's what is their question. Disclaimer is not a protection.
Okay. You see, let me just tell you a very interesting story relating to the domain name. Disclaimers are there, but most of the time disclaimers will not
give protection.
To the advantage of the give protection. Sorry for using this, but this is the decided case. Walmart,
reality.
Walmart.com is there, but someone started using the word WalmartSucks.com. WalmartSucks.com is not connected with Walmart, right? It's a disclaimer. Despite disclaimer, the court held that it is passing off. You're using the mark similar to Walmart. So disclaimer by itself would not. But disclaimer should be to such an extent that it doesn't lead to confusion among the consumers. For example, Walmart. Walmart's word was picked up by shirt manufacturers in US, and they compared this Walmart's activities to Holocaust. Something like when the Holocaust comes, it's going to eat away everyone. Walmart, when it comes, it is going to eat away all the retailers. So in that context, he manufactured T-shirts and sold it under the name Holocaust. Not Holocaust, not Holocaust, Holocaust. And he was sued. And the court said, where is that? Who will confuse you with Walmart? This is a parody that they're making. And therefore, parody should be tolerated. So Holocaust could be used also. No issues with that. Yeah.
Question from Deepavali Brahma. Is there any relation between Trademark Act and the Design Act?
Yeah. There is a direct connection between these two. In the sense that definition of designs under section 2 expressly excludes trademark from its purview. If it's already a trademark, it cannot become a design, right? And section 9, subsection 3, it says that shape of goods can become trademark also, except those three circumstances. So shape can become a trademark, but shape is a design. But if it's a trademark, then it would not qualify for design protection. So that relationship is there between trademark and design. The simple thing is one identifies the source of goods and the proprietor of those goods. The second one is no way connected with the proprietor or the source. The second one is only connected with the eye appeal to the consumer. So one is aesthetic utility. The second one is identification function. That's the difference between trademark and design. Yeah.
Sir, can a trademark owner as well as the design owner, registered design owner, can proceed against the defendant on the same cause of action under the two remedies, both on trademark law as well as the design law?
Yeah.
Same cause of action.
Yes, sir. Yes, sir. I know. The Delhi High Court has addressed this particular issue recently of what is that composite suit.
Composite suit.
Yeah. In case of trademark, it's a question of passing off, and in case of design, it is infringement or piracy. And can there be composite suits or not? And the court has categorically said there can be initiation of two different suits, but both of them could be taken up by the court, right, for decision. But there cannot be a composite suit combining these two issues together, is what the Delhi High Court has said so far. I think Mohan Lal case, if I'm right.
My name.
Yeah. You have not become Lal, sir, now.
My name and
yeah.
also. Lal to be added.
Yeah.
Okay, sir.
All
Question from Vivek Kejriwal.
Although Mr. Harish is wearing Lal shirt.
Yeah, that's
Yes, sir. Mohan Lal case, most probably. Yes, sir.
So, shall I continue?
Yes,
continue.
Okay.
Yeah.
Okay. So, question from Vivek Kejriwal. If a private firm who is providing different types of professional services under one roof, can that firm register his or her name, firm's name, and logo as a trademark?
What is the complication there? Mr.
No
Harish
problem.
already has pointed out clearly that the trade name could be used as a trademark, and you'll have to register that. And if you go for registration, I think you will have an upper hand because nobody else would have used that as a trade name also. And thereby distinctiveness would already be established. It can be. See, previously they used to do what is called as house mark. You know what is house mark? House mark is you have different products sold by you, and for all the different products you're using the same name. That becomes a house mark as such. But now I think that is gone. They're using different marks for different products that they sell. And in case of companies, it is not the launching of the product that is most important for the companies. And they always say, what is important for us is to launch a brand.
Brand name, brand equity, brand name.
Brand. They launch a brand. When they launch a brand, they pick up the blockbuster product of them, and then they launch that particular brand. And launching a brand ultimately gives them the goodwill for other products also.
Yes.
Pepsi has different variants also now. Most of us do not know what are those variants. At least I do not know. One or two I know. Thumbs up is one, right?
Yes.
There are different variants. We do not know the variants. All of us refer only to Pepsi only.
Yes.
Earlier you had Pepsi Cola, but you had different other things also, variants in Pepsi.
Yeah, true.
They have given up.
They have given up now.
So, question from Nitin Gahlot. What is the doctrine of dilution?
Dilution.
Dilution has been
Dilution.
Dilution has been dealt with so elaborately now.
You gave an example already on that, no, sir?
Yeah, Maggie, you should ask them to remember Maggie at least. Right? Dilution.
I think the participant late joined.
If he has not understood that particular thing, I'll just give him the example of that. What is that 40 thieves, sir? Example?
Which one?
Chalice Chor. Alibaba Chalice Chor. You know, that particular girl, the Alibaba had come, sent his followers to put an X mark in front of a house which they
Each
wanted
house.
to attack, right? And that was distinctive now, because they were able to identify that particular thing. And tomorrow that girl went and then put X mark in front of all the houses.
All the
What happened to the first one, X? It got diluted.
It got deleted.
That's it, right? Prasanji is the only person sitting here in the entire hall. And if there are other Prasanjis in this particular room, then Prasanji's distinctiveness is lost here. It gets diluted. Just dilution, simple terms.
There is a similar movie which has come in the name of Piruva.
Yes,
Almira. All the Almiras are of the same color, same design, and the particular hero hides in one of them.
Right, correct. Right.
Dilution.
It's a question from Dr. Chokyo Taku. Sir, what about trademark in networking business run by different production company like Amway, SafeSoap, Smart Value, Avon, etc.? What about online marketing system?
Online? Marketing system. What's the problem there?
He has been highlighted. The question is vague.
So shall I repeat the question?
Vague.
No. Question is vague. If he is available,
specific.
Raise the question.
See, whether it is online or offline, as long as it is not deceptively similar, you can market your product with a particular name. The moment it becomes deceptively similar or diluting, then you are liable for infringement. That's it. That's the principle which applies everywhere, online or offline. Right?
Yes, sir. So same person is asking a different question. Might be he's making it more specific. Sir, what about indigenous crafting? Making at which are made at villages is coming under what type of marketing?
Handicrafts. Village cottage industries and handicrafts.
They can also use the e-platform also now. See, most of the GIs now are using the e-platforms. They all come from the handicrafts in the villages, etc.
Village and cottage industries, handicrafts.
And they have the internet presence now to a large extent. Most of their goods are sold on Alibaba and other platforms.
Yes.
Yeah.
And even startups of those artisans are also encouraged by the government, especially the government of India. Like
A lot of exemptions and all they get. Village and cottage industries, promotion of village and cottage industries.
Correct. They can go and exhibit their products, and the entire cost is borne by the state. Especially in Karnataka, VTPC is bearing all these expenses.
Correct.
Yes, Prashantji.
So question from Sajal Sharma. What will be the three most important difference between a trademark and a geographical indication?
Why three? There are many. First one.
First three.
Yeah, first three. One is an individual right.
Yes.
Other is a collective right. Right? Second one. The quality, characteristics, and reputation are associated inextricably with the geographical origin in case of GI. Whereas the quality is a different attitude, it's consistency of quality that counts in trademark. And the third most important, there are many, but the third most important one. Trademark can be licensed, assigned, etc., whereas GI cannot be alienated at all at any cost. These are three differences. Because you want to only three.
Always sounds so good. When Napoleon Bonaparte was winning every place, and a cannonball used to be fired, and one place there was no cannonball fired, and he asked for calls for the commander and asked for the reasons. Then the commander says there are 101 reasons, Your Highness. What is the first best? There are no cannonballs. So first best always counts so good. Anyway,
I think so the question was also very
appreciate your question. Anyway, next questions.
Okay, sir. Probably this is the last question in the chat box. I have not seen anything more. It is from Shruti Basamatari. Can there be a sale of trademark without the association of the goodwill? Can the aspects of trademark and goodwill be separated?
Perhaps the person who has asked the question could have used an appropriate terminology there. We don't use the word sale, we use the word assignment.
Assignment.
There are only one word used in the Trademark Act, assignment of trademark. And we do not use the word license also in the Trademark Act. We only say permitted user, registered user, that concept for licensing. Can there be assignment of the trademark without assignment of goodwill? Till the 1919 Act came, there was a different position. After the 1999 Act, whether it is registered or unregistered trademark, there is scope for assignment of the trademark without transfer of the goodwill. It's possible. It's permitted. And Section 45 provides that you should register the assignment deed. And in the absence of registration, you will not be able to use that as a evidence before the court of law. And that's the reason why Mr. Harish would say, go and register it first.
That's right.
Yeah, precisely.
No, that's
See, the registration certificate of trademark and the registration of assignment, all these matter very much for them.
very much. Very
We in theory may keep saying that this is the principle, etc. But unless they produce those documents before the court,
nothing more.
Yeah, they can't proceed further. Yeah, that's it. That assignment can be done without transfer of goodwill. That's the present position.
There were two participants raising hands. Are they available? Yes. If they are available, let them directly raise the question.
Gaurav Goswami and Vivek Kejriwal.
Yes.
Anything to do with Arvind Kejriwal?
No, Vivek Kejriwal's question have been already replied. The question was regarding registration of some specific service marks.
Yeah.
But I don't know about Gaurav Goswami, whether he want to. I'm just unmuting him. So Gaurav Goswami, if you are listening, then you can please communicate with your resource person.
They are not interested. Okay. Anyway,
Yeah.
very good.
We have done.
From the bottom of my heart and on behalf of all the participants and even all those from various institutions and the students, advocates, I take this opportunity to give a humble salutation and a standing ovation to the fabulous presentation with the threadbare analysis on various cases, leading decisions. And kudos to Ramakrishna sir and the comprehensive knowledge bearing, and as a walking encyclopedia, you have delineated every aspect of the trademark, touching upon various judicial decisions. Thank you very much. Thank you very much.
Thank you, sir. Thank you so much.
Thank you, Ramakrishna sir. Nice interacting with you, Mohan Krishna sir. Nice on virtual media.
Yes, sir. Yes, sir. Good, sir. Good.
We'll keep in touch.
Sure, sir. Yes, thank you so much, sir. Thank you.
So, thank you, sir, for your wonderful deliberation. And actually, I need not say more because Dr. Mohan sir has already given a vote of thanks on behalf of mine.
I had one statement to make, Prasanjit.
Yes, sir.
When you're talking about Xerox machine, Xerox, yes, the word Xerox, I wanted to mention this. The Xerox is the name of the company. Photocopier is the actual word of the machine which you do the photocopy. Similarly, JCB is a common word used.
Yes, sir.
But JCB is not the name of the of that particular equipment. That equipment which you call JCB nowadays to excavate is an earth mover. Yeah. Okay, but JCB is the name of the original company which came out with that earth movers product. So common man's use, it has become JCB. Like that,
in Assam, any toothpaste you use, but you name it as Colgate, sir.
Sir, in Assam, we use Godrej for all the cupboards and almiras.
Godrej is a similar thing.
Entire country uses the word.
Entire country uses the same thing. For any lock, get Godrej lock, get Godrej cupboard, Godrej safe locker, everything.
For detergent powders.
Huh?
In fact,
detergent powders.
Preeta was telling me that IPR is not very much in vogue in Northeast. I distinctly remember way back in 2005. from National Law School, CIPRA, in association with the High Court of Assam and the High Court of Arunachal Pradesh. I conducted a 6-day IPR workshop, right? And it went on for 6 days. And faculty members from Law College and faculty members from Assam Agriculture University and different parts of Northeast participated in that. A very huge gathering was there, right? And then after that, of course, National Law University has come there. And they have been, and we conducted one conference there also. And Guwahati, I keep coming for IPR works only. You'll be surprised. There is something called as DST, Department of Science and Technology, right? And which has a PIC, Patent Information Cell, in Guwahati itself. And Patent Information Center is found in all the states of Northeast. Tripura,
Meghalaya, Nagaland.
Yeah. I am on the expert committee of this particular DST, Patent Facilitation Cell. And we were trained the officers of the entire region for 2-3 days there. And we keep meeting with them. A lot of IP activities are going on there. I would suggest Prasanjit and then Brahma to associate with them and then find out as to what is the stage at which they are. In fact, just 4 days back, one patent has been granted to a scientist, and that was supported and assisted by this PAC itself. Just 4 days back, they have granted a patent. So that's the kind of work that's going on. And a lot of GI registration also happened from that particular region. I think you must be knowing, you must be knowing about Mogha.
Mogha silk.
Mogha silk. The users were registered
GI
when Mr. Prabhuda Ganguly was there. So a lot of activities are going on in Northeast, and a lot of potentials are there. Especially the potential is with respect to GI and the traditional knowledge, rich traditional knowledge that they have.
First GI was Darjeeling tea. Darjeeling tea.
Yes, sir. Yes, sir. In the country, Darjeeling tea was the first GI.
Both the name and the mark.
Yes, sir. And the
logo and the name.
Sir, and the 370th GI is Sohrai Kova painting from Jharkhand.
Oh.
And I'm happy to say that that is facilitated by my Center for Intellectual Property Rights, which has a unit in Ranchi, supported by the government of Jharkhand.
You need to.
We have another 14 GIs in the pipeline, which we're going to file now.
Excellent.
So a lot of activities in the Northeast we are associated with. I'm sure you should associate with them and then try to push forward the IP activities in your region.
Yes,
a lot
sir.
of potential.
Yes, sir. Actually, sir, there ought to be a focus on the users. Actually, poor peasants, they have the traditional knowledge.
Traditional.
Their interest is to be protected.
Yes,
and that
sir.
has been a striven issue, and which people are not in a position to get the fruits of these intellectual property laws extended to the last poor peasants who have the traditional knowledge.
And different tribal communities.
Keeping in view of PepsiCo, what is that chips manufacturing company, which was it was suing the poor farmers about the intellectual property violations in Gujarat.
Yes, sir. Yes, sir.
We need to just try to focus on those poor peasants and their traditional knowledge is to be protected. And in that area, if there is support from your end, I think our Preeta and other good friends might take such initiative.
Yes, sir. Yes, sir.
By establishing a center for protection of traditional knowledge and the poor farmers.
Yes, sir. That's one huge area that is to be.
That's what, sir. Actually, all these Northeast states put together, there ought to be a momentum towards that end.
Yes, sir. True.
That's what I feel, and I suggest Preeta to take initiative and Prasenjit to follow it up.
Definitely, we'll be taking the help and assistance of all of you. Sir.
Yes, please. I think we can.
Maybe when next time we have that particular expert committee meeting in the Northeast, I'll invite all of you.
Sure, sure.
So that you will be able to interact with those people.
Yes, sir.
Yeah, sure. Yes, sir.
So, sir, thank you once again, sir, for being a part of this session, for giving time to us out of your busy schedule, and for completing the entire concept of trademark, giving a glimpse of entire concept of trademark, each and every aspects of trademark in a very updated manner, with the landmark judgments and various decided examples, illustrations, so beautiful ads that you have shown to us. I know that as a faculty of law or any other participant who are there from law background, they know that these subjects, not only the trademark, copyright, patent, and all these IPR subjects, these are not a cup of tea that we can deal with it just for 1 hour or 2 hours. We need actually a period of long 12 or minimum 15 to 20 lectures to deal with it. But it is very great to see all of you, all the resource persons, including you, sir, that you have so well dealt with these sessions, and we are not feeling that something has been left out, sir. Actually, everything has been touched somehow or the other. So with this regard, sir, I just come to the conclusion of this particular technical session. And not only today's technical session, but we are also coming to the conclusion of the entire 5 days program. So we are just thinking of setting up a validatory session, and I'm very fortunate that I'm seeing all the resource persons here in the screen. And I would also like to now welcome Dr. Gautami Dr. Bora ma'am, principal of Dr. RKB Law College, as well as the chairperson of this 5 days workshop, to deliver her address. Okay. So it will be just a note regarding the 5 days sessions.
She hasn't been seen so far.
She's there, sir. Her webcam doesn't work.
Oh, I see.
Oh.
Himesh sir, if you are there, kindly switch
Himesh
on
sir
your
is here. Himesh sir
camera,
is here.
sir. So switch
Himesh
on the
sir.
video, sir. Okay. I think we can continue. Prasenjit. Paul, ma'am.
Yeah, ma'am. Gautami, ma'am. Gautami, ma'am. Am I audible to you?
Call her, call her.
Ma'am, your microphone is muted.
Let me call her, no? Prasenjit, let me call her.
Madam is seen.
Prasenjit.
Yeah, ma'am.
Okay.
Yeah, ma'am. I'm hearing you, ma'am.
Suddenly,
Yes.
I'm disconnected from the network.
Okay,
Am I
okay.
audible?
Yes, ma'am. You are audible, ma'am.
Now it is my turn, no?
Yeah, yes, ma'am. But I'm not seeing you.
Okay.
Yes, she's seen.
You are seeing, sir?
She's
Yes.
visible.
Yes, she is there.
Yes.
You move towards the right. You get.
Okay, okay, sir.
Okay. So, honorable resource persons, and more specifically, Horish sir, deputy chairperson, coordinator of IQSs of both the colleges, coordinators of this workshop. So we are at the end of the end part of the 5 days national workshop on IPR, and the experience of last 5 days for Dr. RKB Law College, Kokrajhar Law College, and obviously for the participants also, is such that I must say that the experience have indeed been a matter of great honor and privilege to be illuminated on IPR from the very highly distinguished personality throughout the country. In fact, I must say that in normal circumstances, it would not be possible on the part of law colleges situated 625 kilometers far away from each other, and also to be enlightened ourselves from such resourceful delivery in normal circumstances. So I express my sincere gratitude to IQSC cell of both the IQSCs of both the colleges for organizing such a wonderful program. This program was started with a welcome speech of the Deputy Chairperson, Mrs. Prita Brahmo, Principal, Kokrajhar Law College, followed by keynote address by respected Professor Ramesh Barpatra Gohai Sir, Advocate General, Government of Assam. In his speech, he covered the concept of IPR, importance for protection of such right. He stated that IPR is a right that encompasses everything created by human intellect. So, everybody should emphasize on the protection of such right from human rights perspective. Then he mentioned that thought process of the people of our country is protected in our constitution, in the preamble of our constitution. So he appealed to proceed on terms of a constitutional mandate by involving fundamental database research so that bureaucrats may prepare policy on the basis of such data. He emphasized on the transformation of creativity of human intellect towards service of human civilization. Consummate effort for every section of society is necessary for safety human civilization. He concluded his speech with an urge for enacting appropriate legislation for protecting the intellectual property in the property of the people of the country. The topic of the first day technical session was concept of IPR and judicial trend, a perspective. Resource person of the day was Professor Mohan R. Bolla, Principal Krishna Jayanti College of Law. In his delivery, he mentioned very nicely the basic concept of IPR by stating that raising a problem and solving that problem is an intellectual activity, and the right acquired by a human being in this process is the intellectual property right. In his delivery, he mentioned various landmark judgments from the Indian judicial system to highlight the judicial trend on IPR in India. The topic of the second technical session was traditional knowledge, geographical indication, and constitution of India, issues, challenges. Resource person was Dr. Nilotpal Deka, advocate, Guwahati High Court. He covered three basic concepts: indigenous knowledge, traditional knowledge, and geographical indication. He stated that something producing necessarily is indigenous. Knowledge of indigenous people is indigenous knowledge, and the recognized indigenous knowledge is traditional knowledge. He stated that traditional knowledge may be traditional medicinal knowledge, genetic resources such as medicinal resources derived from flora, fauna, etc., and folklore, including folk music. Geographical indication is a sign on product which indicates geographical origin. As such, quality and characteristics of the product due to place of origin, such as Muga silk of Assam, Darjeeling tree, etc. And for recognition, one have to apply for registration under the Geographical Indication Act. He mentioned the provisions under the international documents as well as in domestic law for protection of the geographical indication, and urged for an enactment of a legislation for protection of traditional knowledge in upcoming days. The third day session on an overview of patenting system and prohibition for double patenting, and the program was enlightened by Dr. M.N. Bhimesh, Senior Advisor, LLMT Advocates and Solicitors, Bangalore. He started his delivery very attractively by presenting a video on the first artificial intelligence, Sophia, to show the importance of technology. He mentioned that nowadays inventions by artificial intelligence are also in queue for registration and He mentioned that Thomas Alpha Edison have patent right over 1,039 inventions. With a beautiful video on Jugaad, he highlighted the importance of protection of those inventions created through Jugaad in India. In his speech, he covered various international documents for protection of patent, as well as domestic legislation and procedure for protection of such right, as well the provisions for double patenting. In the fourth day, we have enlightened by the resourceful delivery of Professor Dr. Srinivasulu, NS, Professor of Law, National University of Judicial Science, Kolkata. He stated that literary work is the beginning of all other work on which copyright is granted. he mentioned that copyright is something different from other intellectual rights due to the moral values involved in it. And for this reason, additional protection of 60 years after death of the right holder is recognized. He highlighted on the correlation between media and the literary work, on the Copyright Society, which works for protection of copyright, and also for the also legal issues related to infringement of copyrights. Then topic of today's technical session was on an overview of trademark, which was highlighted by Dr. T. Ramakrishnan, Professor of Law, Chairperson, IPR, National Law School of India, University, Bangalore. In his delivery, he mentioned that trademark is a psychological function of human being over a symbol. That symbol, that is the trademark, indicates a distinctive character of that product. It is the merchandising shortcut that helps the purchaser to select a particular product. Trademark may be granted on the shape of goods, packaging, combination of color, signature, etc. He mentioned that generic and trademarks are mutually exclusive. He stated on the grounds of absolute and relative, on the grounds absolute and relative for refusal of registration. His entire session covered various examples on trademark to make it understandable to the participant. The benchmark of the entire 5 days program is the presence of Advocate Horace sir, who throughout the entire session very actively participate with other resource person and also interact with the participant and thereby enlighten us on various aspects. I express my sincere gratitude on behalf of organizing committee to all the resource person, Advocate Horace sir, participants to be a part of this program and thereby make it a successful one. Thank you very much.
And our good friend Diganta has shown his face after a long time.
Yes, sir. Yes, sir.
Diganta.
Yes, sir.
Thank
Very
you,
fine. I have learned many things from the program you organized this time. This is a 5-day program and so many issues have been discussed, and I am really feeling enriched as I joined the program.
Okay, so good to hear such very well
Yes,
narrated words. Okay, please. And, yeah, go
Sorry.
ahead.
Thank you, Gautam ma'am, for your note regarding the entire workshop. So, last but not the least, I would like to call upon Ms. Shilpi Gupta ma'am, the coordinator of IQAC cell of Dr. RKP Law College, as well as the co-convener of this workshop, to deliver the vote of thanks.
Am I audible?
Yes.
Yes, ma'am, you're audible.
Yes.
Okay. Good afternoon, everyone. Honorable guest, respected speaker, chairperson, deputy chairperson, members of organizing committee, dear participants. It's my privilege to propose a vote of thanks speech and acknowledge the contribution of those who worked hard to make this national workshop on intellectual property a grand success. I, Shilpi Gupta, convener of this workshop, on behalf of the entire fraternity of the organizing committee, at a very outset, extend my most sincere vote of thanks to our keynote addressee, Professor R.C. Borpatra Gohai, Advocate General, Government of Assam, and former Dean Law, Guwahati University, who spared time from his busiest schedule to inaugurate this workshop. I extend my hearty vote of thanks to all the speakers without whom the workshop would not have been possible. Our deep sense of appreciation for Professor Mohan R. Bollab, Principal of Krishtu Jayanti College of Law, Bangalore, for his explanation on IPR and judicial trends. We are grateful to Dr. Nilutpal Deka, Advocate, Guwahati High Court, for demonstrating his idea upon traditional knowledge, geographical indications, and Constitution of India. Next, I like to express my gratitude to Dr. M.N. Bhimesh, Senior Advocate, ALMT Advocates and Solicitors, Bangalore, for giving an insight upon patenting system and prohibition for double patenting. I also like to express our sincere thanks to Professor Dr. Srinivasulla S. Professor of Law, National University of Juridical Science, Kolkata, for excellent coverage to copyright law in literary work. Sincere vote of thanks to Professor T. Ramakrishna, Professor of Law and Chair Professor, IPR National Law School of India University, Bangalore, giving an oath of trademark. I would like to take an opportunity to place on record my hearty vote of thanks to Chairperson Dr. Gautami Datta Bora and Deputy Chairperson Ms. Preeta Brahma for the logistic support and guidance they have extended to all of us at this workshop. I also extend my vote of thanks to the entire team of organizing committee for their enormous cooperation in the organization of this workshop. Last but not the least, I extend my hearty vote of thanks to all the participants who have actively and patiently participated and cooperated with us and made this workshop a grand success. Once again, I thank to everyone for all of your kind cooperation in entire workshop. Thank you.
Preeta, if I may.
Yes, sir.
Yes, sir. Yes, sir.
Yeah, just a compliment to one of the faculty members. See, I was telling you that a patent has been granted recently, and faculty members from Guwahati Institute are also here. This is Dr. B. Sharma and team from the Department of Physics, Guwahati University, who have been granted patent for AZO sputtering target for manufacturing transparent conducting film. Right, this was facilitated by PIC, and the patent was granted. Certificate was issued on 25th of June 2020, just a few days back. Let me congratulate him if he is present here, or through his colleagues. Let me congratulate that great scientist of Guwahati University. Thank you so much.
So if he is there, we can just even hear from him something.
Yeah, why not?
I don't think he's there.
Is it there?
No, he's not there. Yeah, he has not joined our workshop.
Dr. B. Sharma from Department of Physics. Okay.
Preeta ma'am?
Yes.
If you want to say something.
Sir,
because
I personally
it is for you that it was so successful.
I personally would like to take the opportunity to offer my heartfelt thanks to all our speakers for accepting our invitation as an invited speaker within a short period of time and giving us your precious time and devoting us some of your time in order to transmit the knowledges that you have with regard to IPR. And Sir Ramakrishna sir, heartfelt thanks. Yesterday we were so nervous that sir is not picking the call. What will happen? Whether sir is in some problem. So we were in dilemma. So, but in the end, then it went well. And in the end, when you received my call and then you said that yes, everything is ready, but you were busy with the workshop at ULC.
So Mohan knows that, right? That
yeah,
happening.
Yeah, but it happens, but it did not recur, fortunately.
I was also there, Mr. Ramakrishna sir. I was also there yesterday at ULC.
Yeah, that is when Preeta was calling me.
Yeah.
And when I'm in webinar, I keep the phone right away, little away.
Yes. Yeah, that we know, sir.
Yeah.
But anyway, sir, thank you. And Bhimesh sir, thank you. I know you are there, but maybe due to some network glitch, not able to see you. And Mohan Rao sir, thank you. You make the workshop very lively, and I have been a fan of yours since Christ for being so jolly and lively.
Thank you.
And,
thank you very much.
Sir Harish sir, meeting you for the first time. We'll keep in touch, sir, with you.
Sure.
So nice to see you, and it's all because of Mohan Rao sir to be able to see you and interact with you.
I know. I am thankful to Mr. Mohan Balla for this. Otherwise, I would have not been probably on this.
You should only extend your resource support to Preeta to organize.
Sure. Always.
Yeah.
All of you.
Pleasure, sir.
Indeed, pleasure meeting all of you, to get to know all of you. We
Pleasure,
shall
sir.
keep in touch.
Special appreciation
Yes, sir.
to Mohan Krishna sir also.
Yeah.
Yes, sir. Today you joined, sir. Thanks to you, Mohan Krishna sir, for joining in the end day. Prasenjit, thank you. You have been a...
He was not visible, that's all.
Oh.
Today also sir was there, I think.
He is there. Mohan Krishna is there.
Prasenjit, thank you for being the moderator throughout the program. Thank you to
thank you, ma'am.
convener,
Thank
chairperson Gautami ma'am, and my colleagues from Kokrajhar Law College. Thank you all the participants for joining this workshop. Your presence have made it a grand success. All thanks to you, and your queries have enlightened
Actually.
the concept of others as well. Thank you for joining, all of you, sir. And if it would have been
Thank
a
you,
physical workshop, we would have been so happier to welcome you with our traditional garlands.
Oh,
Yeah.
okay.
We hope to see you, sir.
Yes.
But along with garland, don't have good jalokia, that's all.
Yeah.
Spiciest chili available in Assam.
Yes.
In the entire world
Okay.
next to the green chili of Britain.
We all are very
Yes,
eager
sir.
to visit your place and make a program there collectively like this.
Yes.
Yes.
Sometime very soon.
Sir,
Sir.
both the colleges are too far away. Principal ma'am has already addressed it, sir.
625 kilometers.
Okay.
Himesh sir, I can send you bhoot jolokia from my garden.
Oh,
Good.
Okay, sir. So, I
Peter,
think so.
please,
Yeah.
please mention about the certificates also.
Oh, yeah, yes.
the participants.
Dear participants, we'll be sending you across the participation certificate by 15th. It will be dispatched. So kindly hold on patience for another 3 days. And today's feedback and assignment will be available to you very shortly. So kindly fill in your today's session feedback and assessment by tomorrow. We'll give you time till 11 p.m. And with this, I think, sir, we can end, no?
Yes, sir.
Sir.
Thank you.
See, Guwahati, I have one more very strong bonding with Guwahati. Right? Connection, very strong connection with Guwahati.
Okay.
And perhaps Preeta will be surprised, and all faculty members of they will be surprised.
Okay.
My son is the son-in-law of Assam.
Oh.
My daughter-in-law is from Guwahati proper.
Okay.
Oh, nice, sir, nice.
Very
And
great.
Mohan was saying, you saw my daughter-in-law here, right? First day. Yeah, if Preeta had
granddaughter, you were saying.
Granddaughter.
Yeah.
If Preeta had spoken to her in Assamese, she would have spoken in responded.
Oh.
She will do that now onwards.
Thank you, sir. In the lighter vein, I just wanted.
Excellent, sir. Good, sir.
Good to know about your daughter, your family, sir.
Yeah.
That your
And
daughter-in-law is
relationship
from
with
Assam.
Assam.
The
Yeah.
relationship.
Okay, sir. Okay.
Thank you.
Thank you, one and
Thank
all.
you, sir.
Thank
you, everyone.
Ending on a pleasant note with granddaughter's issue.
Okay. Thank you.
Thank you, sir.